Lordship, I beg to mention item number 2 on behalf of N. Pada. This matter may be kindly listed after 3 weeks, my lord. Since due to domestic issue, he's out of station.
You're taking consent for the other.
Yes.
Consent.
Then, my lord, this item number 1 also, my lord. I need some more time to file rejoinder affidavit, my lord. These two matters are connected, my lord. Why, my lord, connected? Because, my lord, this item number 2, the lane LPC lane where I was allowed the contract work to construct the building. That time government says this is your private land. Now in item number is where the government is saying no, entire land is forest land. So these two matters are connected, my lord. After vacation, my lord.
Okay. Make it together. Check. Or rather make it different orders. On the, in item 1, you say on the prayer made by Mr. R. Singh, counsel to the petitioner. Sorry, appellant, the matter is adjourned today. For government, who's there? I am for. You're there, Miss. Government advocate is present. And item number 2, here you say that on the prayer made by the counsel for the private respondent, matter stands adjourned today. This one, we'll do it after vacation. Okay.
Deeply obliged, please.
Maybe separate orders.
My lordship. Lordship, I beg to mention item number 4, lordship. Learned amicus curiae, Master Titi Tara is out of station, lordship. Matter may be fixed after 1 week, lordship.
Okay, both sides are represented. List after a week is paid for by, paid on behalf of the learned amicus curiae.
Obliged.
May I mention item 5? Here, my lord, I have been appointed as legal aid counsel, and I have received the paperwork recently. And then I have been conveyed that PT also not available today. Is he out of station? This matter may be fixed after 1 week or 2 weeks.
Both sides are represented on the prayer made by the legal aid counsel. List after 2 weeks.
Okay.
Yes.
My lord, we are furnishing the status report. My lord. There has not been any work because of the monsoon season. They are likely to resume in the first week of October. This is carpeting, my lord.
But you see, in almost all the northeast states, this monsoon will come every time.
Yes, my lord, that is
Correct. This is pending since July.
yes.
Now, in the ground of monsoon, how much time we will take?
My lord, as per this instruction, by the first week of October, it is likely to resume the work is. Because in during the monsoon, the plant for bitumen mixing plant also.
The difficulty is, show us the, what is the time of completion, date of contract?
My lord, that was long time back, my lord. This
It's in
project.
2008.
Huh?
It's started in 2000. It's more than 15 years.
2008.
2008. Yes, and it's been extended for 5 times. The contract's extended for 5 times.
Now,
You terminate.
my lord, there has been so many.
If somebody is from 2008 to 24, how many years?
No, my lord,
Yeah.
earlier that again, these contractors, they have been requested again.
That can't happen. Call the, this authorities here in court. If it's a road construction pending for 2008 and now we are in 24, 16 years. I think the officers will have something to answer.
Yes, my lord, there has been so many litigations on over this, so many cases. Thereafter, ultimately, my lord, again, the carpeting work, the construction work has begun, my lord. There was pendency, my lord. It has begun, and now this presently they are taking up the matter very seriously, my lord. There has been so
Inside
many.
my chamber, I am very serious. It is only outside here I just smile and laugh. I grant all adjournments. When I am in chamber, you see, I am a terrorist. Nobody comes to my room.
There has been a long history over this.
No, I am
work.
also saying same thing.
Yes, my lord.
In my room, nobody enters. I am such a terrorist. It is only here you find me a different man. If the officers are very serious in their office, let them come here and let us see how serious they are in the court. You see, officers are serious. Do we have to teach them how to run their office? Why do we take up, we call these officers?
Yes, my lord, in fact,
Let us learn in their career how many contracts they have terminated. Very serious people.
My lords, actually in the prayer section, we have mentioned for the monitoring, a special monitoring committee may be formed, so court may be monitored.
No, we
Otherwise,
we don't need monitors for people who are the top. They can't be monitored.
actually, your lordship, it's been 1 year that it's already filed, and as per the communication from the petitioners, they are saying that they have been constructed for 1 month or two after that is stopped it for showing that they are constructing.
You ask them to bring their records with regard to their bar chart. Mr. Ratan. Every contract was, they must prepare a bar chart.
my lord, there was earlier a status report, my lord, submitted.
No, status report we won't understand.
The reason for delay has also been mentioned, my lord.
No. Please tell us from the record, show us a document by which milestones are given, provided. Where is the document where you have given us the milestones?
That, my lord,
In a contract, there must be a milestone. Show us which document has the milestones. If not, ask these officers, somebody in the top to come here on Friday.
my lord, because there was change in the executing this agency also. Earlier, it was the Gammon India Limited, my lord. Target was till 2012. Again, it was re-awarded to, because of they couldn't complete, re-awarded to Gammon Engineering and Contractor.
And in the
Again, that
process-
also was
and
sublet.
in the process from 2008 till now, how much is the price escalation?
Might have been. And there was a revision also.
We understand that. Very serious people.
So earlier, against the earlier incumbents officers, there were cases also,
I
SIC
understand.
cases
You
also.
see, you have said that they are serious people and
Yes, ma'am.
I'm just thinking aloud how serious these people are. A contract of 1 rupee becomes a contract of 100 rupees. And that will not happen if they work a new contract. So they are very happy with 2008 contract, price escalation. All these officers, let us interact with them.
Yes, Malot. Therefore, earlier, against the earlier incumbents, Malot, the officers, SIC charge sheet also has been filed. Now, this is a new incumbent, Malot. The officer, and now they have taken up, seriously, my lord.
That's why, how serious they are, we want to know. You're not giving us the bar chart, you're not giving us the timelines, you're not giving us anything.
My lord, as for this, that instruction timeline has not been given, my lord, of course.
You see, if you want to delay, you can merely say that, well, in the highway, somebody dropped a basket of garbage. And therefore, unless that garbage basket is cleared, our trucks cannot pass. PWD trucks, contractors' trucks carrying sand, they may get damaged with the garbage.
As per the earlier status report, my lord, the target was supposed to be September 2024. Subject to, of course, they have said, subject to fair weather.
So please tell us, when these serious people work, they don't take into account these monsoons.
So, my lord, can it be fixed after a week so that the latest status report, whether they have resumed or not, ma'am?
We
And
don't
then
need status
the
report.
specific time frame.
Satan, I don't understand engineering. I don't understand status report. Because I told you an example. I
Yes,
am very good in giving horrible examples. One of the example is in some village, a person drops a bucket of garbage on the road. And now the contractor says that unless you clear that garbage, my trucks are very sophisticated, they can't pass. Then there's monsoon, then again there will be Durga Puja, we will not get labor. Then there will be January. It will be a picnic time. Entire January goes like that. Then we will have in March, April, we have Holi, Bihu. Very difficult to work. And again, mid-April, monsoon will come. And these serious people are so busy thinking. We want to see how much serious they are. Please call them. Next week, when give a date.
Next week.
They will give us two things. Bar chart of the work, the natural impediments, including holidays when they can't work. Don't give us the dates where they can work. Give us the dates when they can't work.
Let it be, my lord, then
Give us a date,
26.
26th.
Yes, my lord.
And please tell us what is the. They must have done some work. Factors may have done some work.
Yes, my lord.
What is the defect liability period? Has it expired?
No, my lord, defect liability period will be, will run after the completion, my lord.
After the.
Yes, my lord.
Please tell us from the records. If the work is not yet completed,
Yes, my lord.
and you have some carpeting was done,
Yes, my lord.
correct?
Remaining,
How much expenditure is made annually for carpeting?
my lord will kindly see the earlier status report. There we have given, my lord. Status report of 1st July. Yes, my lord. We have,
So you want to see the.
yes, my lord.
See the expenditure done in the name of carpeting.
Yes, my lord will kindly see in the table. Black topping is one. Physical. Yes, my lord.
Things which are apparent.
Yes, my lord.
Page
Specific
2 of the status report. Come, page 2 of the status report.
page 2, yes, my lord.
Yes, paragraph 1.
Yes.
Project, this project, the construction and improvement of so is still under investigation of SIC. This has also affected smooth execution of work due to seizure of relevant documents. Now, where is the letter by which you wanted a copy of those documents for progress of the work and you were not given by the investigating agencies? You got applied for copy and then you make a statement that because the document is achieved, you can't do the work.
Yes, that is there.
So who teach this?
Of course, my lord. That they have to apply, my lord.
If the documents are there, come summer, come winter, come autumn, nothing will happen.
In fact, the very officers, they were under that investigation, my lord.
Then those people who are inside the jail, forget that. But what about the officers who are there, very serious person? Very seriously there.
This is the subsequent new incumbent, my lord.
If they are serious because they don't know how to take the documents from investigating agencies. They know will to work. 18 years for 81 kilometers.
There were so many litigations. My work was stopped completely for 2-3 years also.
Some corrections is I'm getting the order, but there will be some corrections.
Because that resuming of this work, it also took place after so many cases now.
You see, wherever I start reading, there is a big gap, big hole. You have done everything which somebody can, not to work. You want to see that? Come here. Brief report in the page 1, brief report, paragraph 4. Adverse climate conditions, heavy rainfall, remoteness of the area having only 6 months working period annually. Now, for every contract, there is a clause that you will inspect the site and take the work. Now, these people who are the contractors, if you not inspect the site, now is it permissible for the state to say that they could not work? You have made the contractors told not to work. You are conscious of the fact that officers should not be brought to court. They should be allowed to work there. But is this the permission to do work? Delay in drawing of extended agreement in 2017. You want to say that in 24 also the drawing is not there. Our contract of 1 year, drawing was given in 2017.
Drawing of it should
Can't work.
delay in extending the agreement, my lord.
See, we are giving the status report. The status report says delay in drawing of extended agreement in 2017. If there is a delay till 2024, the agreement is not signed, will they work? It's your status report.
Yes, my lord.
Then who is responsible?
My lord, here, therefore, the change in subsequent,
Now please tell us. I say, second half. You asked me, this police station at East Tamil district. In this road, 81 kilometer. Tell the police station to send us the copy of FIR. Where law and order situation is so bad that the contractors can't work in 81 kilometer stretch. Item number 1, law and order at site. At 2 o'clock, give us the, we'll resume again, at 2 o'clock, give us the FIR. There is law and order situation there.
no, my lord, here, my lord, there might not have been entered any FIRs, my lord. There are,
You see, can a state take cognizance, state responders, can they take cognizance of a law and order situation where there is none? There is no FIR, there is no law and order situation, you say that there is law and order situation. Now this officers will have to do something. Law and order means,
well, practically here, there are disturbances, my lord. Of course, there are no, sometimes no
state take
FIRs are lodged.
Tell us as the law officer of the state,
Yes, my lord.
does the state take cognizance of a law and order situation merely by presumption?
Of course not, my lord.
Then-
State is not taking, my lord. The officers, they are, what they are facing.
State must speak in one language.
Yes, my lord.
It's not that the home department will speak in another language. PWD will speak in another language. The other authorities will speak in another language.
Of course not,
Is there a
my,
language problem?
my lord.
Yes.
This is the status report of the executing in a PWD, my lord. What the officers there,
We want the solution.
yes, my lord.
If there is a law and order situation, stop it. By all means, stop the construction outflow. Go to the people and tell them law and order situation is bad, we have stopped all the contractors. In this district, if there is no development work going on, not PNRD, but PWD, this housing, no department is working,
No,
agriculture.
development works are going on.
Why can't they work? Law and order situation is so bad. Why will the doctors work? If something will happen like West Bengal. Stop everything. You see, when you bring before the constitutional court, an issue which is saying that there is a law and order situation, what should we do? Supreme Court has directed SIT. It is given the matter to CBI. West Bengal Calcutta High Court has given the investigation to CBI. We also do it. Then come to number 2, land acquisition problem at site. Now, if there is a land acquisition problem, can you work? What is all this rubbish? You are issuing a contempt notice against these people who have given you this. Let us see, you issue a contempt notice. These people who are giving you a status report, which is completely false, rubbish, and piece of trash. You want us to believe that any of the things? Number 3, dispute in the query site. So no stones will come, no boulders will come. The query site is closed. Now, if this query site is closed, does your mine engineering department agree to it? Mines is under whom? Query is under whom? Forest.
Mines and Minerals Department of Mines.
Mines and Minerals.
Yes, ma'am.
Has Mines and Minerals Department vetted that this query given to the contractors has a dispute? You have a department they sell every year. Query,
Query, my lord, here, my lord, it is not always a government notified query, my lord.
Okay.
There are private queries also, private landowners, my lord, in the queries.
You see, X is the contractor. Y is the queryman. It is not a government lease. You will go to Y and ask, take a certificate that there is a dispute in his query. And the work will stop. Don't take us for granted. By holding project works in 2015 in one of cost revision. So if the cost revision is not yet settled, which contractor will work? And you are not producing as the documents that the extension of work was without any cost escalation. There is no documents you are filing. You just give a status report, want us to read, and waste our time. Which part of this is substantiated by any document? Which tell us?
My lord, in this status report, of course not, my lord.
Then we issue a contempt notice against this case. Who is this officer who has given this report? Executive engineer. We are issuing a contempt notice against him.
This was just a status report, my lord.
Understand, but this status report must say something. Everything is trash. It's just a rubbish.
If required, my lord, let them give an explanation on how they have.
No, we'll teach that. You don't have a school where they learn how to write status reports. We teach them. Don't like that. After 60 years, this is what they tell us. You want us to read further? Shall I read further?
My lord, this was the status reports submitted, my lord.
This status report must mean something. They intended to convey something from this status report. I've read only 5 paragraphs. Do you want us to read more? Not how we. It's not content against this. Yes,
Sonam Somu.
Suna.
Somu.
Then we are in Madison.
No, yes.
Valid additional. It had 170. Scan copy of the status report. It appears. Yeah. Yeah. The project of construction and improvement of facility dash road within bracket 51.0 kilometers in each town of the state was tendered and the road
It's in 2008. It started in 2008, yes.
very best.
If your lordship may come to synopsis, the notification was issued in 2006, but work started in December 6, 2028. It's in the synopsis second para.
There going to certain anomalies in the work. Certain trials were high. There to investigation by the special investigation cell. It is also affected that certain officers and so what would be it is also predicted that the subcontractor engaged principal contractor terminated part of the work funded by the entities and only from table one. That was before. I think as of March 2024. Except that of it. And the balance work as in around every 2024 respect of that topic is 45.745 kilometers. For delay. As provided in the status report. Is number one. The situation of site. Forward. Prior entry for the law of the situation. The second round of delays is land acquisition problem and size. So please understand that there is a lot of solution of the land acquisition problem and size. How?
Yeah.
Progress is achieved. Third round. It's good in 30 seconds. This is a liquid that we produced by the government agency who has reached out to say the concern very site. The participants also become exposed which very site for providing measures for the schools and measures for the such way down will right side can fall down to the down. This adverse climatic condition of heavy rainfall and remoteness of the area having only 6 months working period annually. No material resistance has to the factor before succeeding within the world. Expanded itself with the conditions at site. Now, it is holding project works in 2015 in one of cost division. Support cost division. How will the respondent or the language get to go? If the delay in the planning of the state is limited to 20. This how about the yes. So this complaint can be this union of organizations. This round of the months of the and copy of audits that today on account of the division. No, the things that is supposed to take respondents. Let's do this. Basically, that. Which always. Lead to SIC litigation. Why? A project should be stalled, really because agency is investigating. That occurred. This means execution of the work, the seal of the documents pertaining to the project. This document also not supported by, in order of report, or by the investigating agencies, refusing to part with the document, received documents. Which is affected. They don't have the wisdom to receive copies of sealed documents from these investigating agencies. Which we know, the better work. For this section was not even real. Okay. Here, what is the considered opinion? In substantive common opinion that metals have been deliberately suppressed. Preventing the inventing with the anchor lights. The court is constrained to give notice to the executive engineer, Giant and CHAY in the deputy engineer. The court should not take a view. Insufficient evidence of and prevent the court. The establish facts. The executive engineer, Scientology, the deputy engineer, if court is not satisfied, which is ground of science. No. Okay, disclosure on the. Open to the problem. The initial action is to set the purpose. So, contemplate. Going on the content proceedings. Then set a problem. For deliberate substitution on identity facts. That is also the notice to on the board. For the project, it was actually. The extensions were issued without cost extension. With cost. The PWD party. The National Economic Code. As to whether. The Northeast Council. It is Northeast Council or Northeastern Council?
Notice council,
Not
notice council,
East Council.
yes.
Or any other agency of the government of India. Has agreed. To share the escalated cost. Of the road. Of the road. And. What is the plan from the state? To. Fund the balance. Work. If. Money to the. Government of India is not. Respondents can also produce. Copy of the updated. Part justice. Inspector of the work inspector. Showing the various. Milestones. Indicating. How much delay is being achieved. It gives us cost in achieving the milestone. Send a download copy of the service. Responding. Including the executive engineer. Showing budget. To the division. There will be additional information. Not 10. How much time?
But let it be then after 2 weeks, my lord.
Give it 8 was either to respond. Give it 8.
After, let it be on 22nd then, my lord, October.
Second. 9.
22nd is Sunday.
October. 10. Yes, earlier it was been recorded, my lord. Yes, ma'am. My lord, the status report today's, that also may be kept as a part of record.
No, this was something where this compared to my. Now you see, we are producing before us status report. You have the status report of what's the line.
Yes, my lord.
You see page 2 of the report. gives a typical status of NEC funding.
Yes,
Correct. It's very interesting to read this. Let us say, for example, one item. Formation cutting. Correct.
yes,
Formation cutting is 100%.
yes,
5.618 kilometer, physical 5.618 kilometer achieved. From the progress report and the state funding, this work is not there.
yes,
Correct. Now come to blacktop issue, which is table one, last item. Total road is 81.0 kilometer. Correct.
yes,
Out of NC fund, blacktopping is 100%. Sorry,
35.61,
6.5 kilometers. Correct.
yes,
And 45 is remaining. 35 plus 45 is 80.
yes,
Correct. Now from state fund also in blacktopping, 15 kilometer. Is it not over? What do you call, what do you say? Overlapping? 80 kilometers you have come, you are showing it from NC fund. And again 16 kilometers,
yes, my lord.
is it like this,
This has to be, yes, my lord.
these big shops like Pantaloon and all giving,
Clear, yes, my lord. Yes, of course, my lord. Yeah. How black topping of 16 point this kilometer has been shown
Right.
above 81 kilometers, my lord.
yes, Miller gift and Puya gift. Buy one, get one free.
Yes, I'll seek this clarification on this. Yes. I'll seek,
You can read this.
yes, yes,
So leading the state right. Nothing but leading the state. Everything, WBM, P 81 kilometers you have completed. From state fund 35 kilometers again.
yes, I'll have to, why they have,
WBM to 81 kilometers completed out of 80 kilometer road, 81 kilometer, 81.360 kilometers done. And from state fund, 20 kilometers again done.
I'll have to seek clarification. My lord, there might be something, my lord. There should be something. Otherwise, why they have segregated state fund and the NEC fund?
Here small people, people are.
This, my lord, will speak.
Whenever they give scheme, I go there. Check in the net. If I get something less in big basket, I go there. If something is less in Amazon, I go there. If something is sold at less in Big Bazaar, I go there. That's my. For small people. You will find in all of these cases where election cases are there. The Supreme Court has found a different word. In election matters only. Supreme Court has used the word little man.
Little man.
Yes. Little man is borrowed from English literature. There hasn't been. They don't say poor man, they don't say small man. They say little man.
My lord, today's status report may also be kept as a part of record, my lord.
Status quo. Anybody who's acquainted with, for the government, are you acquainted with the revenue department handling the flood? Do you have any idea of
Revenue Department,
the scale, that revenue? Of the deputy commissioner office dealing with the flood. Are you acquainted with the working system? No.
no, madam, sir.
You will be knowing. Disaster management.
Disaster management.
Disaster management. Who is the partner lawyer? Or you deal with it?
I don't think so. There is any separate council for.
Let's say this consult the disaster management department. We require them also.
Whether actually this flood happened or not, madam.
I think so. I have some experience on the state of Assam. Many districts during the disaster, like floods and all everything. It is required for the disaster management department to make a report of it. Correct. So in this case, we would need the disaster management department's report in regard to flash flood in the working area of this one. Correct.
You have the directorate,
Directorate, we
Register.
have. Yes,
and district also you have the branch of.
branch,
there,
yes,
Under the deputy commissioner.
yes.
Maintained by the. In this area. This will be. Work is going on and where. Pressure plant and bitumen plant. At Marjinga, MARJINGA.
No, district and disaster management department भी है ना.
What is the urgency?
Well, this is, as per the schedule, it has to be, if it was supposed to be listed within 2 weeks and it is not already.
May I, Lordship? Lordship,
Was placed.
I beg to mention item 20 here, Lordship. We are supposed
Item?
20, Your Lordship.
Yes,
We are going to file our affidavit, Your Lordship. So I need at least 3 weeks time, Your Lordship.
20.
Yes, Your Lordship.
You're taking consent of the other side?
Yes, Your Lordship.
Okay. How much time you need?
3 weeks time, Your Lordship. 3 weeks time.
3 weeks time. Okay. Both sides are represented. List after 3 weeks so as to enable Ms. P. Pangul and a government advocate to file affidavit in opposition in the matter.
Oblige, Your Lordship.
May I please, first I beg to mention item number 12. Which by mapping on behalf of K. Bui for the petitioner. Due to some personal difficulty, he couldn't appear. Kindly this matter may be fixed on 4th of November.
No, but we've allowed this RVC. It is, you were permitted to address this on.
Interlocutory application is pending in this matter. Interlocutory application is pending in this matter.
Please put the speaker close to you.
Yes, Lordship. Interlocutory application is been pending in this matter, Lordship. Item number 12.
What IA?
Yes, IA number 149 of.
What is that for?
Yes, Lordship, there's an implement for necessary parties in the writ petition 119 of 2002.
Any objection to this IA?
Notice may be issued for the IA. Notice,
Yes,
if notice may be
yes.
issued for the.
Why notice? If you have no objection, why notice?
We will file objection on the IA.
Registered society under the Society Registration Act, representing by its General Secretary, Lordship. The society is a Ubint Welfare Society, Lordship, who are the indigenous inhabitant of the Vijayanagar Circle.
What is the writ petition for? Writ petition is filed for?
Actually, Lordship, the writ petition was claiming a compensation of Namdafa, the villages of the within the village Namdafa area, villages of the writ petitioners, by asserting that its territory jurisdiction also extend beyond the traditional land of these IA applicants, Lordship. Therefore, these IA applicants are the necessary parties in this matter. Otherwise, any directions in the writ petition direction by this honorable court will have a ramification in the interest of the Ubin society, Lordship. Therefore, it has to be made a necessary party solution.
Okay, just wait for some time. When the matter is called, we'll pass orders in this case.
Right.
May I, Lordship, I beg to mention item number 14. I'm mentioning on behalf of counsel for the petitioner,
Why this has come for orders? Why this has come for orders? Why it is listed in the orders column?
My lord, I'm not concerned with the brief of the case.
No, just wait, it is in orders column. It may be steps has not been taken, we don't know. Wait for some time.
Yes, sir.
My lordship,
Yes,
lordship, I would like to mention item number 7. lordship.
item
7.
7.
Yes, lordship.
Yes.
Lordship, I have to file a short additional affidavit, lordship. I am putting petitioner, lordship. Moreover, lordship, I have taken the consent from the other side, lordship. After 2 weeks, it will be.
On the prayer made by learned counsel for the petitioner, list after 2 weeks, so as to enable him to file additional affidavit in the matter.
Over. My lordship, I beg to mention item number 1. Senior governor still is out of station, so matter may be fixed after a week. Item number 1.
Counsel for the petitioner is out of station. Just a minute.
Lordship. This may be fixed for admission hearing. We have filed our affidavit already here, counter. Nothing is encroachment matter. Lordship.
Just a moment.
Yes. We have filed our affidavit already. Lordship. Initially, Lordship,
Just a moment.
Lordship may see the last page of our affidavit, Lordship, NHR 7, page 30. This is a total encroachment of the Lordship water tank, Lordship, by the PHE department. Of the PHE department, I'm sorry.
Okay. Your name?
B. Sivo.
Huh?
B. Sivo.
B.
Sivo. On behalf of T. Tapap.
Mr. B. Tibor, learned counsel appearing on behalf of the learned counsel on record for the petitioner. Also heard. G8 and advocate appearing for. Your designation is government advocate?
Additional senior
Additional senior government advocate for the state. Next, I've seen that the respondent number 3 has already filed an affidavit in opposition. And the petitioner has also filed 2 additional affidavits in the matter. Therefore, court is inclined to issue notice returnable in 2 weeks. 2 weeks.
Lordship.
Returnable in 2 weeks.
Lordship,
Without
2
requiring any
weeks.
first steps to be taken, as all the respondents are represented.
Lordship, in 2 weeks time, it will be vacation already. Lordship, can it be next week? Because this is enforcement matter here, Lordship.
Okay, let's have 1 week. Okay, Land management, Mr. Kamdar is there.
Here. The main party is the Deputy Commissioner Pasigat Lordship, which we have filed already.
Okay. Mr. Accordingly, list the matter for admission on, give a date next week. Yes. Oh, yeah, they Mr. D. Kamdu for the land management department. We should notice.
Yes, ma'am.
Yes, next item,
May I listen, another item, item number 28,
item
28.
28.
Yes, on behalf of T Tabak.
Okay, you have taken consent of the other side.
Yes,
Okay, all sides are represented on the prayer made by Mr.
B Sivo,
D.
B Sivo. B Sivo.
B. Sibo, Learned Counsel appearing on behalf of Mr. T. Tapak. Counsel for the respondent, the matter stands adjourned today. List after
4 weeks.
4 weeks.
Lordship,
Yes,
in item number 28, I'm for the petitioner. Interim order may be continued.
okay, interim order passed today stands extended till the next date of the stay. Yes,
May I also, I beg to mention item number 6. Also,
Six.
Yes,
yes,
I'm for the petitioner. We need to take instruction from the client. Here, the main proprietor is no more today. Here, the main proprietor is no more, right? Proprietor, item number 6. So we need to take instruction from his family. So this matter may be released after 2 weeks.
okay. List after
2 weeks.
2 weeks so as to enable the learned counsel for the petitioner to take updated instructions in the matter. Okay, government advocate is present. List after 2 weeks.
Bless.
Okay,
My lordship, I beg to mention item number 8 and 9. Lordship. I'm
8
for the
and 9.
petitioner, lordship, leading counsel Triti Tara is out of station.
okay. Both
Madam
sides are
Ma-
represented on the prayer made by learned counsel for the petitioner. List after 2 weeks.
Lordship, fixed date may be given, 4th October, lordship.
This, after 2 weeks, we have this puja vacations, we don't have that fixed date.
Also with item number 9, there is an item number 9. Interim is there.
Okay, interim order passed and list stands extended till the next date of the stay. Yes,
Obliged. Also, I beg to mention item number 11. I may be allowed to withdraw this petition also, since my prayer has been considered by the respondent.
you want to withdraw it?
Yes.
Okay. Both sides are represented. Next, upon instructions, Mr.
Hari,
R.
Ingo.
Ingo, INGO. Learned counsel for the petitioner submitted that the respondents have addressed the grievance of the petitioner and accordingly he has instructions not to press the matter. Mr. Accordingly, this writ premises stands closed having not been pressed.
May I lordship, I beg to mention item number 21. In this matter, we have to file our rejoinder. 1 week time may be granted.
21,
Yes, my lord.
you are for the petitioner.
Yes, I'm for the petitioner.
Okay, both sides are represented. On the prayer made by learned counsel for the petitioner. List after 2 weeks so as to enable him to file rejoinder affidavit in the matter.
Lordship, there is an interim, earlier interim order. Shall we continue?
Okay, interim order passed today stands extended to the next date of the stay.
May I plead your lordship, my lord, I beg to mention item number 19, my lord.
Nine.
Here, my lord, we need to file our affidavit, my lord.
Yes,
So, my lord, I need 3 weeks more, my lord, to file
3
affidavit.
weeks.
Yes, my lord.
okay. Both sides are represented on the prayer made by learned government advocate. List after 3 weeks so as to enable her to file affidavit in opposition in the matter. Simple. से दिखता नहीं है बस पे लग जाएगा नाम दिखता नहीं है पढ़ने में नहीं आता जी yes
Yes, may I lodge? Yes, Your Honor, this is petition regarding the service matter, Your Honor. Your Honor, Department of Education and issued advertisement to fill up the vacant post of 36 PGT and TGT for meritorious sports person quota, Your Honor. Why the advertisement number ED2 DAC 460 APT 2018 on dated March 2020, Your Honor. And the petitioner 9 in numbers.
okay for secondary education who is appearing secondary education you have instructions in the matter.
Your Lordship, the learned counsel is unable to present because due to some unavoidable circumstances.
Okay. Right. Mister,
Yes, sir.
You are L. Gillian. Your name?
LG then, Your Honor.
L. Gillian, learned counsel for the petitioners. Agreed by the non-declaration of the results of the recruitment to the post of PGT and TGT under meritorious sports person quota. The present writ petition has been filed under Article 226 of the Constitution of India by 9 petitioners who are presenting common cause. Next, for issue notice returnable in 4 weeks. Mr.
A Podo.
K.
Podo.
Photo POTO.
PODO.
Learned counsel that accepts notice on behalf of
Tagun Jamo. T Jamo.
T. Jamo, standing counsel.
Oh, sorry, my Lordship. Taba Tagum.
Taba Tagum. He's counsel for secondary education.
Yes.
So standing counsel for the secondary education department representing respondent number 1 and 2. So 1, 2, and 4. Who is appearing for Department of Law? Any government advocate will appear for Mr. S. Kapil, the senior government advocate, accepts notice on behalf of respondent number 3 and 5. Who?
Respondent number 3.
You have a 3.
I'm for 3.
And who is for 5?
Race Lordship, I think my pen
5?
will be okay.
Okay, also for 5 also. Okay. Accordingly, extra copies of the writ petition will be served on the learned state and department closet within 2 days. Next para, list after 4 weeks. Next para, dependency, before that you write, pendency of the writ petition shall not be a bar for the respondents to declare the results if deemed appropriate.
Obliged.
Yes.
May I, my lord? My lord, page 20, my lord. What happened, my lord? I had filed an RTI before the public information officer. Now, within 30 days, after expiry of 30 days, my lord, I have filed a first appeal, my lord, before the first appellate authority. my lord. Now, first appellate authority also did not, my lord, adjudicate upon my first appeal within the 30 days and outer limit of 45 days, my lord. Now, what happened, my lord? I filed a second appeal, my lord, before the State Information Commission, my lord. Now, State
Where is-
Information Commission, my lord,
Where is the first appeal?
page 35, the impugned, my lord.
No, where is the first appeal?
First appeal, my lord. Yes, my lord. That could be, my lord, page 23, my lord. It was received, receipt copy is at page 25. my lord. My RTI application is of 27/6/2024. It was received on 28/6/24, page 25. my lord.
No, we will not entertain writ petition of this nature. You want a declaration of 50,000 or more of 2012. We are now in 24. After 12 years, you want that.
What
record.
I say, my lord,
So please show us from the rules of executive instructions
my lord.
that the government is required to preserve records for how many years?
My apprehension is that there has been some mismanagement of fund, public fund.
You
So I am a, my lord,
I'm asking
practicing
you a
advocate.
question.
Yes.
As per the rules under executive instructions,
My lord.
how long does this vouchers for payment is required to be maintained by the concerned department?
It must be maintained, my lord, because
No. Either you are saying it without knowledge, without instructions, or you are
at
misleading the
least
court.
they should have the courtesy to
No,
look me into the records, my lord.
that will not
Furnishing of
be, that
information
will not
is-
be there. That will not be there.
Well,
Every state government has a time limitation to preserve the original records.
Yeah.
After that, because these are the government accounts.
yes, my lord.
Government accounts are recorded in the single book entry system. And after 6 or 7 years, after maybe 8 years, depending on the rules of the state, the original vouchers are destroyed and only the books of accounts are maintained. And
But-
therefore you are not getting it.
No, my lord, it can be said by the PIO, my lord. PIO is saying nothing, my lord.
We don't know about that.
My lord,
We are not on that.
my lord.
But the
My lord,
question is a question of law.
Uh,
For how many years you are asking for a mandamus?
Yes. Mandamus or direct the State Information
No.
Commission
Please
to
satisfy us
adjudicate
that
upon-
the records are available. You don't
Yes,
want
sir.
us to pass an order
My lord.
where people will get the order and laugh at us.
My lord, I am against the procedure, my lord.
Mr. Picha,
Yes, my lord.
what you are against,
My lord,
God will help you.
my lord, my lord,
I'm asking you a legal question.
my lord.
For how many years does the original, the state government rules permit an original voucher to be maintained? It's as
That,
simple
my
as
lord,
that.
I do not have the, my lord, instruction, but
Then it will presume it to be 7 or 8 years. And this is a 12-year-old writ petition. I'm dismissing it in limine.
my lord, in that case, my lord, I will maybe given some time, sir, so that I can satisfy.
You're giving
In
you time,
regard
but you're
to
not
the-
asking for it.
My lord.
I'm giving you time to respond.
Yes, my lord.
Do it. Otherwise, it will not be maintainable.
But actually, I am against the, my lord, this proceeding, my lord. The procedure adopted by the Information Commission.
2012, you are wanting it.
My lord.
You want it for extraneous considerations.
No, my lord.
Anything is not legal.
My lord-
Your requirement of 2012 is not lawful.
My lord, may I
So
please
ulterior
come,
motive.
my lord, may I please come to para 2, my lord. Or para 1, page 7, my lord, of the writ petition, my lord. Para 1.
Yes.
That humble is a so and so and so. Further, it is the petitioner is a practicing advocate in the Court of Judicial Magistrate First Class, so and so, Tawang, my lord. So for para 2, my lord. The facts of the case is that being informed by the reliable source that there has been used mismanagement of public money by the Office of the Executive Engineer Public Health Engineering Department, Tawang Division, from the year 2012 to 2016. Petitioner
see-
being a public.
Mr. Picha,
Yes, ma'am.
there is a second reason to dismiss your writ petition.
Alright.
If you can cure it, tell us. Paragraph 2, you start by saying the facts of this case is that being informed by reliable source.
Yes, my lord. I have the source, my lord, but I
Please,
cannot.
please, I am not completed.
Yes,
I am not a straight man. I am a straight man like a jalebi.
my lord,
They're very twists and rounds.
my,
They're not very straight. Correct?
my lord,
Because I come from the place where you are standing.
my,
In my earlier career, I was standing there.
my lord, my lord,
So that has taught me to be straight like a jalebi.
my lord.
Correct? Unless you allow us to complete, you will not understand what I'm trying to say.
Yes,
Paragraph 2 is the facts of the case is that being informed by reliable source that there has been huge mismanagement of public money.
my lord,
Correct?
my lord.
Come to page 16, 18.
18, my lord, yes.
Yes. In affidavit paragraph 2 is matter of record. That means you have the record,
I have the source, my lord, but I cannot reveal, my lord. That is the thing, my lord. The petitioner says.
but your affidavit is record.
No, record is this, my lord, this annexures. This annexure is the record, my lord. Because my lord, the para 3, my lord, the statement made in so and so
No.
are
I'm
two by,
not on, you see, I'm not finished with paragraph 2.
oh, my lord, para 2.
Paragraph 2 is a matter of record.
Para 2, my lord, it consists of annexure 1 series, my lord. Para 2, my lord, it consists of annexure 1 series, my lord.
Yes.
Para 2, my lord, it continues till page 9, my lord. That is annexure 1 series, my lord.
Yes.
This is with regard to records, my lord.
No, that is one part.
My lord,
Record is one part.
my lord.
Paragraph 2, first 2 lines which I have read is
Yes.
also a part of record. He has not bifurcated the affidavit by saying
Right.
part of paragraph 2 is true to my information.
My lord.
So it's a matter of record. That
Because
means
the
you have the
documents,
record.
my lord, documents which I am annexing, my lord, that is the part of record. But
No, no.
other things, my lord,
I don't know. You are writing an affidavit. I
Right.
don't know. I'm just reading what you have
my
written.
my issue is, my lord, whether the deputy registrar, my lord, deputy registrar can adjudicate upon my second appeal, my lord. At least, my lord, give me some time so that I can produce some materials, my lord. That voucher should be
No, no,
maintained.
2012, we have no business to open up this 2012 matter.
2012 to 2016, my lord.
No. No, I'm
At
discussing
least-
it in limited.
at least one
is
term may be
something
given
not
now.
entertain. This is something the High Court will not entertain.
But
Yes.
I'm on the procedure, my lord. I'm on the procedure, my lord.
Pardon me?
Procedure, my lord. Procedure
we-
adopted by
we
the
take note
Information
of that.
Commission.
We take note of that, but I'm this
And more, my lord, yes.
in cash.
That is why, my lord, I have a serious apprehension, my lord. I have the source, but I cannot reveal, my lord. I know, my lord, there has been some mismanagement of fund, my lord. Now, without any proof, how can I prosecute this, my lord, this executive magistrate, my lord? Oh, sorry, this officers, my lord. At least I should have some proof, sir.
You see, without proof, how can you have a how can you
I have
arrive
an
at a-
indirect access.
No, no. How can you arrive at a conclusion that you want to prosecute them?
My lord, I have the reliable source, my lord.
No, no. This High Court will not be a instrument to give you documents to allow you to prosecute these people.
No.
It is after 2012.
My lord,
You
this,
see, the presumption is
my lord,
that this man who was there in the helm of affairs in 2012 is now due to be promoted to the post of chief engineer or additional chief engineer. And therefore, now you have come up to rake up this issue so that his promotion can be stalled.
not
I
like
have that
that, my
presumption.
lord.
Tell me I am wrong.
Not like that.
What is the position of this man in 2012 who was the executive engineer in 2012? What is the seniority position now?
No, I don't know, my lord.
We give you time till 2 o'clock. Find out the seniority position of.
I don't have any knowledge whether which executive engineer was posted at that point of time, my lord. What
And
I
you
am
want to
saying, my
prosecute
lord,
him.
there has been mismanagement of fund, my lord.
And you want to prosecute him.
Yes, my lord. At least, my lord, at least give me 2 weeks time, my lord.
Sounds a good music to the ears.
No, but at least give me 2
No,
weeks
no,
time,
no,
my lord. I will, my lord,
I'm
satisfy.
dismissing it in limine.
My lord, this applicant,
This can't be entertained. This RTI business must stop. Not from the order of the court.
My lord, this at least, my lord, give me one week time or 2 weeks.
No, no, not even an hour's time. I can give you time till 2 o'clock. If you can tell me the status of the executive engineer against whom you
I
want to
am not
proceed.
against someone in individual, my lord.
No, no, you see, please. I told you I was there
My lord,
where you were standing.
my lord,
You said that you want to prosecute.
my lord.
Whom will you prosecute if you don't know whom are you wanting to prosecute?
Yes, my lord. After collecting the documents, I can prosecute, my lord.
No, you can't permit that. Heard Mr. B. Pichal and counsel for the petitioner. Also heard Mr. Oh, you can agree to his prayer. I did not ask you.
No, my lord.
No.
Rightly pointed out those things.
Mr. R. Segia Leonard, standing counsel for the
1, 2, 3, 4, my lord.
respondent numbers 1 to 4.
1, 2, 3, and 4, my lord.
Next, madam. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the order passed by the State Information Commissioner. Sorry, Arunachal Pradesh Information Commission.
My lord, deputy registrar, my lord. Deputy registrar, Arunachal Pradesh. It has not been adjudicated.
Page
Page 35, my lord. 35, 35.
It's by the Arunachal Pradesh State Commission.
But the my lord, RTA Act says, my lord, it
No,
can
no,
be
this is written,
adjudicated.
this is by an authority.
Deputy registrar.
No, maybe, but it's
No,
doesn't-
whether he can adjudicate, my lord. As per
No,
the
he has
act,
not
my lord, it
adjudicated.
is the Information Commission, my lord. State Information Commission, not the deputy registrar. my lord. This is a legal proceeding. my lord.
Through a communication dated 30/8/2024 issued by the Deputy Registrar APIC Itanagar on the ground that the first appeal has not been adjudicated by the first appellate authority following due process of law by having proper hearing of the parties and or without passing a reasoned and speaking order. But then, Mr. Sagia, your first appellate authority must.
My lord, under section 19(3), my lord, the second appeal has to be filed against the decision made by the, my lord, first appellate authority, my lord. Here, my lord,
Where is the first appellate authority order?
no order has been passed, my lord, by the first appellate authority, my lord.
No
The
adjudication. my lord.
condition is that, my lord, within the time prescribed for disposal of the first appeal, my lord, the first appellate authority has not passed any order, my lord. So, my lord,
Then also appeal will lie. This,
no,
information is-
appeal will not lie, my lord, because appeal will lie against only order passed by the, my lord.
Right to
RTA.
inform.
May I read, my lord? Section 9.
Unless I have the book, I will not understand.
I'll just read the sentence.
Get the book, otherwise I will not be able to follow you.
May I pray, my lord? Item, section 19, subsection 3 and subsection 6 may be read conjointly.
Get the
Yes.
book.
19(3) and 19(6). my lord.
Yeah, 2005.
Yes.
Section 19(3) is the second appeal, provision for the second appeal.
Okay, then this order must go.
And then-
Read three. A second appeal against a decision under subsection 1 shall lie within 90 days from the date on which the decision should have been made
Yes, my lord.
Has actually passed. Actually received.
or was actually received. So if within the time of 90 days, they don't do, second appeal will be allowed.
My lord, my submission is that, my lord, if they don't, my lord, pass any order, my lord,
You see, please tell us. Somebody files an appeal.
My lord.
Your second appellate authority does not decide it within how much time?
Within, my lord, 19/6, my lord, 19/6,
30 days.
30 days or extended period of 45 days. Section
Okay.
19, subsection 6, one.
Appeal by the concerned authority will be within 30 days. Now, what is the time for this first appellate authority?
My lord, 19/6, my lord, 19 subsection 6, my lord,
19/6.
6, yes, my lord.
Will dispose of within 30 days or extended period not exceeding 45 days.
Yes, my lord.
So if 45 days doesn't he pass, 3 is very clear on the date on which the decision should have been made.
Should have been, yes.
In my submission matter, it provides, it reflects for the section 18B and C matter. If matter,
Mr. Saikia,
yes, matter.
Mr. Saikia, no, please tell me, if somebody has not passed an order, what will the appellate authority do? It will reject the appeal or it will remand the matter back to give a direction to the second appellate authority to pass an order? What is right?
Again, there is a power of the information commission, although it is not a revisional jurisdiction matter. But it says matter, section 18 is some sort of revisional jurisdiction matter.
No, according to you, you think that the order is justified. That if the second appellate authority does not pass an order, you dismiss the appeal.
No, matter.
You don't have the duty to ask the first appellate authority to pass an order.
Information teacher ought to have filed a complaint before the information commission, not appeal matter.
Shows the provision,
Matter, section 18 matter.
section 18. Yes,
Power and function of the information commission.
Yes.
Subject to the provision of this act, it's the duty of the Central Information Commission or the State Information Commission, as the case may be, to receive and inquire into a complaint from any person member. And kindly B manner, come to B manner, who has been refused access to any information requested under this act, and C manner, who has not been given a response to a request for the information or access to information within the time limit specified under this act manner. Because the PI has also not responded, my lord. Against the non-responding of the my lord, by the PI, they have filed the first appeal before the first appellate authority, my lord. Therefore, their first appellate authority has also not responded, my lord, so they have filed second appeal.
if you are relying on 18, your officer should have been converted this into 18.
That is another aspect, my lord.
No, for these things you shouldn't punish a citizen. This application is absolutely wrong. But this order I can't sustain. Because in these grounds, if I dismiss the writ petition, it will be injustice to all the other citizens who have a right to apply for RTI.
By the impugn order, my lord, it was not dismissed, just returned the second appeal, my lord.
No,
So,
we
my
have
lord,
converted it. We'll directly.
either, my lord, here, the commission also have converted it, my lord. And in the instant case, my lord, commission has returned the, my lord.
No, he can't return. Can't return.
So instead of coming to this honorable court, my lord, they would have.
No, you
filed
see,
a-
tell us, I will give a parameter example. You see, for example, injunction under order 39 1 and 2. Any party agreed by an order or not passing of an order, appeal will lie. Now, can the appellate court will say that no, we don't entertain the appeal because no order was passed? It's not permissible. 19, you see, please come to this 19. They are both under chapter 5. 18 and 19, 18 which you are referring and 19 are under the same chapter 5,
Same, my lord.
power and function. So appeal is otherwise maintainable. The act does not say that somebody without complying with 18 cannot come to 19. Is there any restrictive clause there?
Yeah, that is not there, my lord.
No, then
But,
we can't do it. If there is no restriction clause, we can't permit a citizen to be No, we are allowing this. Why notice? Why punish Mr. Pichamore?
In fact, section 18 has been, my lord, settled in State Chief Information Commission versus State of Manipur.
Submissions.
My lord, further, I want to submit, my lord. In terms of this act, my lord, another Pradesh has also framed a rule, my lord. The procedure of filing appeal, my lord, is there, my lord.
Give this act. Unless it rules.
Rules essentially, said, I know. Important implementation of. My lord, this is called, my lord, Arunachal Pradesh Information Commission Appeal Procedure Rules 2005. And kindly see, my lord, rule 3. Here it refers, my lord, finding of the order passed by the first appeal.
Okay. Heard Mr. B. Pichatan, counsel for the petitioner, as well as Mr. R. Sekar and standing counsel for the respondents. Next, madam. The case of the petitioner is that he had filed an RTI application before the public information officer. Where is your application?
It would be at page 20.
20. PHED, Tawang Division, seeking certain information. Pertaining to period from 1/1/2012 to 31/5/2016. Full stop. Being aggrieved by non providing of information, the petitioner preferred a first appeal before the designated authority, i.e. the superintending engineer, PHED, Shergaon, SHERGAON division, West Kameng district, which is dated 11/6/2024. No, sorry, 27/6/2024. Full stop. The petitioner posits that before the PIO as well as before the first appellate authority, the requisite payment by way of challan was made. So Section 6, Section 19, the Right to Information Act, 2005. or subsection 2 is required to be disposed of within 30 days of the receipt of appeal or within such extended period, not exceeding a total of 45 days from the date of filing of such appeal, comma, as the case may be, comma, for reasons to be recorded in writing. Full stop. Full stop. The petitioner, next paragraph, the petitioner claims that after filing of the first appeal, comma, the required information was not provided. And accordingly, second appeal was filed by the petitioner under section 19 within bracket 3 of the Right to Information Act, comma, 2005. Full stop. It said appeal is dated 26/8/2024. Comma, which was filed before the State Information Commission, comma, accompanied by the requisite appeal fees. Full stop. The second appeal was received by the Office of the Arunachal Pradesh Information Commission on 26. What is the date? 26?
My lord, returning date, my lord.
Page 34. What is the date?
This is 26/8/24.
26/8/2024. Full stop. However, by the impugn letter dated 30/8/2024, the registrar, Arunachal Pradesh Information Commission has returned the appeal filed by the petitioner for the following reasons assigned. Page 35, pencil mark. Yes. Next paragraph. Next paragraph, the aggrieved petitioner has assailed the said communication dated 30/8/2024 with further prayer to direct the respondent number 6, i.e. the public information officer, to provide the information. Next paragraph. Defending the impugned communication dated 30/8/2024, the learned standing counsel for the respondent numbers 1 to 4 has submitted that the order is that the return of the appeal is justified three and 4 of the Arunachal Pradesh Information Commission within bracket appeal procedure bracket closed rules, 2005, there is a prescription of about the contents of the appeal and the documents to accompany appeal. So accordingly, it is submitted that as the requirement, as the appeal of the petitioner was not complying with the requirement of clause 1 of rule 4 of the said 2005 rules, comma, the appeal was rightly returned. Next paragraph, it is the further submission of the learned standing counsel for the respondent numbers 1 to 4 that under the provisions of section 18 1 C, small c, of the Right to Information Act, comma, the State Commission can be moved by a complaint by the petitioner who has not been given response to a request for information within the time limit specified. And therefore, it is submitted that the communication, impugned communication is justified, and the petitioner may file a complaint as required under, as prescribed under section 18 of the Right to Information Act, 2005. Next paragraph. Referring to subsection 3 of section 19, this will be next paragraph, of the Right to Information Act, 2005, the learned standing counsel for the respondent numbers 1 to 4 has submitted that the said provision also requires that a second appeal would be maintainable against the decision by the decision by the first appellate authority under subsection 1 of section 19 of the said act. Next paragraph. Moreover, it is submitted that as this is only a motion stage, comma, if a notice is issued, comma, he would obtain instructions and to file, so as to file an affidavit in opposition in the matter and therefore pays for issuance of a notice. Next paragraph. On a it would be relevant to quote the provisions of subsection 1 and subsection 3 of section 19 of the Right to Information Act, and also to quote the provision of Rule 3 and Rule 4 of the Arunachal Pradesh Information Commission, within bracket, appeal procedures, bracket closed, rules, 2005. Next one. The issue to relates to information which is sought for by the petitioner. Therefore, in such matters, the delay in adjudication by issuance of notice will not serve the purpose for which the Right to Information Act 2005 and rules framed thereunder have been enacted and notified. Because of the possibility of delay in adjudication of these trivial issues. Accordingly, issuance of notice in the matter is dispensed with, and the court is inclined to dispose of the writ petition on merit at the motion stage without issuance of notice on the respondents. Next paragraph. From a perusal of the provisions of Section 19(3), it is crystal clear that a second appeal is maintainable against a decision by the first appellate authority, and the appeal shall lie within 90 days from the date, inverted commas, on which the decision should have been made, inverted comma closed. Full stop. A further reading of the said provision is also indicative of the fact that an appeal would otherwise lie within 90 days from the date on which a copy of the decision is actually received by the person seeking information. Full stop. There is nothing contained in Section 19 of the Right to Information Act that an appeal under Section 19 within bracket 3 is impermissible without due compliance of filing of a complaint as envisaged under Section 18 of the Right to Information Act, 2005. Full stop. In other words, Section 19 of the 2005 Act is not subservient to the provisions of Section 18 of the said Act. Full stop. Next paragraph. Therefore, the comma. In the absence of any restrictive clause in the provisions of Section 19 of the Right to Information Act, which debars filing of an appeal unless a complaint is made within the meaning of Section 18, 1 within bracket C of the 2005 Act, the court is of the considered opinion that it was incumbent on part of the second appellate authority, i.e. the State Information, the Arunachal Pradesh Information Commission, to adjudicate the second appeal on merit. Next one. Coming to the prescription of the 2005 rules. I'm sorry, Rule 3 of the 2005 rules. The comma, though under clause 3, Roman 3 of Rule 3 requires mention of the particulars of the order against which appeal is made with the relevant particulars of the state public information officer who has passed the order. But under no circumstances, comma, the 2005 rules can be allowed to override the prescriptions, the prescription of law, which is made under subsection 3 of section 19 of the Right to Information Act, comma, full stop. No state amendment has been brought up. The operation of section 19 within bracket 3, unless a second appeal is disposed of on merit by providing or refusing to provide information. Full stop. Therefore, comma, clause Roman 9 of Rule 3, comma, which requires that the appeal should contain any other information which the commission may deem necessary for deciding the appeal, comma, has to be read in consonance with the intent and purport of section 19 within bracket 3, which permits a second appeal to be filed within 90 days, inverted commas, from the date on which the decision should have been made. Full stop. Therefore, comma, a disclosure of such information in the appeal memo filed before the second appellate authority would be sufficient for the said authority to exercise its jurisdiction in entertaining an appeal under section 19 within bracket 3 of the Right to Information Act, 2005. Stop. Next para. The requirement of documents to accompany the appeal is already extracted herein before, comma, which is prescribed under Rule 4 of the 2005 rules. Stop. The requirement of clause 1 of Rule 4 is that attested true copy of the order against which the appeal is preferred is required to be disclosed. Stop. However, under clause as already stated, as already held hearing before, comma, the intent of rule, subsection 3 of section 19 of the Right to Information Act, 2005, is to permit filing of a second appeal, even if no information is given within the prescribed time limit. To stop. The prescription of clause 1, Roman 1 of Rule 4 cannot be allowed to defeat the intent of section 19 within bracket 3 of the Right to Information Act. So therefore, in the considered opinion of the court, comma, in the event appellate order is first appellate order is not available, comma, if a disclosure is made by the party seeking information, that his or her appeal was not adjudicated. The first appeal was not, sorry, no order was passed in the first appeal. A disclosure of such material under clause 2 of Roman 2 of Rule 4, which requires copies of documents relied upon by the appellant and referred to the appeal, is appended to the memo of appeal. That would constitute an appropriate disclosure by the petitioner for the second appellate authority to entertain the appeal. Full stop. Next paragraph. The issue raised in this writ petition is a pure question of law, requiring interpretation of the provisions of section 19 within bracket 3, 18, 1B, and 18, 1 within brackets small c. Read with Rule 3 and 4 of the Arunachal Pradesh Information Commission within bracket Appeal Procedure bracket Rules, 2005. The court is inclined to hold that an appeal under subsection 3 of section 19 would be maintainable by an applicant on whose application no information was provided and on whose first appeal, no orders were passed. Stop. Moreover, it is also held that section 19 of 19 within bracket 3 of the Right to Information Act, 2005 is not subservient and dependent on compliance or filing of complaint as envisaged under section 18 within bracket 1 of the Right to Information Act, 2005. Full stop. Next paragraph. Resultantly, it is also declared that the absence of any order in the memo of appeal, when no such order is passed by the first appellate authority, would not entail dismissal and or return of the appeal in view of absence of any restrictive clause, that unless all the contents as enumerated under clause 1, Roman 1, TO2, Roman 9 of the 2005 rules is it cannot be filled up. The appeal would not be maintainable. And accordingly, the lack of the absence of order, if disclosed in a memo appeal in terms of clause 9 of Rule 3 and clause Roman 2 of Rule 4, would be sufficient compliance by an applicant whose on whose application, the information is not disclosed by the state public information officer and or also by the first appellate authority. Next para. Resultantly, in light of the discussions above, this representation stands allowed at the motion stage without issuance of notice on the respondents. To stop. Consequently, the communication number 235, number so and so, dated 30/8/2024, is set aside and quashed. To stop. The second appeal preferred by the petitioner stands restored to the file of the Arunachal Pradesh Information Commission, and the petitioner would be permitted to refile the said second appeal before the said authority within 30 days from today, and on such refiling, the Arunachal Pradesh Information Commission shall entertain the second appeal. Next para. Before parting with the records, the court is inclined to observe that if the Arunachal Pradesh Information Commission was made aware that no order was passed in the first appellate by the first appellate authority, instead of returning the appeal, it could have converted it into a complaint as envisaged under section 18 within bracket 1 of the Right to Information. Next para. Calculation stands allowed to the extent as indicated above.
Much of it.
We'll make it photocopy and then we'll give it to you. This page.
There were some private respondents also, madam.
That has been dispensed.
I've dismissed with the notice, issuance of notice.
Yes.
photocopy करके return कर दीजिए।
Hello.
But in this case, I have raised two issues. One is for giving unequal treatment to the equally situated person. Secondly, for violation of section 30 of the Lara Act. But this simple notice may be issued. We will take it up. The things. Because authorities do not have made a distinction between the two groups.
Okay. But whenever this writ petitions comes, the only anxiety I have, because many times in the evening I have no work, I roam about in the roads. But locally grown cardamom, I never get. Now I've started getting
This issue, last time also.
local grown. I've started getting local grown walnuts. It is in that near that hospital. There is a van which sells. Many times I've visited that and I purchased a lot of
Well,
what
as
do you
far as
call this,
production of cardamom is
No,
concerned, well,
I-
there is,
you
but
see,
then,
I'm not questioning anything, but when these things come, but the only anxiety is that in the nearby areas, locally grown cardamoms are never available.
but in Yazali area, it's highly available.
I don't know.
But not at the large scale as it was in Anjao.
No, I don't know. I'm not making any comment. I'm just saying that I don't find in market, but yes, walnuts have started getting here. Last time also, when I
Last time
came,
also,
I
Malaj
purchased.
Lordship was narrating your that incident of when you had visited in Jiro. You stopped over at Yazali, you
Yes,
couldn't find
zero.
anything there.
Before you enter, there's a market. It's not available.
But
You know, incidentally, since it is local grown, I purchased what is the walnuts at almost twice the market rate available in Guwahati. Just because it's a product of this region, and otherwise those walnuts which we get there are of origin is of California.
well, walnut and persimmon, especially the persimmon, it has come up, a huge production has come up in the last
I'm not
2 years.
I'm not taking that, but it is
From-
only because of some interest on the for the interest of the economy of the country. I purchased walnuts at twice the amount of in which walnuts are available in Guwahati. Guwahati, the last purchase which I made was 450 rupees a kg. And here it is not available below below 900 at here. In Tawang, my wife recently went last week and she got it at rupees 700.
Very costly.
Although it is cheaper in Guwahati, but since it's a product from Varanasi, I take pride in purchasing it from here. Even at twice the amount. Zero, it was 700
Yes.
last week. I'm issuing a notice.
But 1 and 2 are state government, and 3, 4, and 5 are Union of India.
As Mr. Tom Patel and Council for the Petition.
Standing council. No?
Issue notice in this repetition, file under Article 226 of the Constitution of India. Whereby the petitioner has paid for reassessment of the compensation to be paid to the petitioner by taking into account the rate of cardamom, solatium, and interest on the award issued under the right to fair compensation and transparency in land acquisition, relief and rehabilitation act, 2013. Stop. Petitioners, yes. Mr. D. Kamdut, Leonard, Standing Council, accepts notice on behalf of respondent number 1. Mr. S. Tapin, Leonard, Senior Committee Advocate, accepts notice on behalf of respondent number 2. And Mr. M. Kato, Leonard, DSGA, accepts notice on behalf of respondent numbers 3, 4, and 5. So extra copies of the repetition be served on them in the course of the day. Next para, list on. Notice is made returnable in 4 weeks. At least after 4 weeks.
Not only one observation that pendency of this repetition may not be a bar if they come to a
Pendency of the repetition shall not be a bar for the respondent authorities to take an appropriate decision in the matter.
obliged.
Yes, my lord.
Yes, Mr. Patil. When I see you, I remember your tree. outside the gate. When I see you, I remember your planted tree outside the gate. I always see that.
Oh.
Yes. And I also remember the president of the bar. Look at this UPI bar. I forgot the name. Huh? No, no. District bar. Down Rigam. I remember him because when I came long back to inspect the ongoing construction, I saw that young man doing gardening in the court compound. He was having that, on a Sunday, he was having that local dao and equipments, and he was doing gardening. He had planted about 40 trees. Some of them died. But I'll never forget of his great work of doing the gardening himself. It's a wonderful contribution to this compound by him. Yes.
Yes, here in the case, my lord. The executive played probe to nullify the court order. I have challenged the Departmental Promotion Committee minute
Who are you?
of 4 petitioners and my
You are sub-inspectors.
huh?
You are
Yes,
sub-inspectors.
Arunachal Arms
Okay.
Police Battalion.
Okay.
And my serial number is petition number 1 is in 8 and petition number 2 is in 11. But that is the seniority list. But I'm not concerning with the seniority. And here in the case, seniority is irrelevant. My contention is that since this is governed by the recruitment rules of 2008, and as per the recruitment rules of 2008, the ratio of promotion and recruitment is 80-20. Now, as per the recruitment rules, the total strength of the inspector force is 12.
No, in your repetition, you have said that the ratio of promotion is 50:50, 80:20, and 75:25.
No.
Para 5. Para 5.
Para 5. Para 5. Huh? Para 5. Yeah, here, my lord, there are categories. Categories is 50-50, that is A group, and B 80-20, and 75:25, that is D group, C group. So my case is fall under non-gazetted group B. Now, the impugned order, this matter initially, 4 departmental promotion committee was held earlier. There, I was not given promotion. So I have challenged and the court has passed all judgment in my favor. And court has directed to consider my case. And what the executive has done? The promotion was cancelled as per the directions of the Guwahati High Court in WPC number 92 of 2015. But again, they have given the same person in the 5th Departmental Promotion Committee. They have again promoted the same person whom they were initially appointed. And while they have made the appointment, promotion was given, they have given from the back date of earlier promotion order, which was set aside by the Guwahati High Court. Now, Impugn order, which I have challenged, is in page 18.
Page 50,
Page 18, 1-8.
1-8.
Yes. Now, here we will find everything. The Departmental Promotion Committee was informed that the contention of the petitioner have been examined in the direction of the Honorable Guwahati High Court, Itanagar, Permanent Bench, Naharlagun, dated on 5/5/2017 in WPC number 92 AP of 2015 in the matter of Sri Anjan Roy and others versus State of AP and others have been complied with by issuing an order number such and such dated on 1/4/2019 cancelling
Mr.
its
Patel,
earlier
we'll have to
order
continue at 2. We'll have to continue at 2.
2. Page 18, serial number 2. The Departmental Promotion Committee was informed that the contention of the petitioner have been examined in the directions of the Honorable Guwahati High Court, Itanagar Permanent Bench, Naharlagun, dated on 5/5/2017 in WPC number 92, AP 2015, in the matter of Sri Anjan Roy and others versus State of AP. Others have been complied with the issuing of and such and such.
You're reading which page?
1/8.
1-8.
1/8, yes. Cancelling its earlier order. Their promotion was cancelled. Dated on 26/11/2014. This is the date of promotion by who is Sri Tapok Butin and Sri Lindum Komi, SI, Arunachal Arms Police Battalion, had been promoted to the grade of inspector. The now vacancy post out of the 12 sanctioned posts of inspector Arunachal Arms Police Battalion, there are 4 clear vacancies available for filling up through promotion from the feeder cadre of sub-inspector. Now, recruitment route. The Subedar Inspector Arunachal Armed Police Battalion Group B, gated non-ministerial recruitment rules 2008 provide that the method of recruitment to the post of inspector Arunachal Arms Police Battalion shall be by promotion from platoon commander sub-inspector Arunachal Pradesh Armed Police having 3 years continuous service in the grade of platoon commander sub-inspector. The post of Subedar Inspector Battalion is a selection post. Now, as informed by the department, the following 20 sub-inspector AP Arunachal Armed Police Battalion, all under the zone of consideration, according to their inter-se seniority. Here, out of 20, the petitioner number 1 is in serial number 8, and petitioner number 2 is in serial number 11. That means they are not denying that I am not qualified. They say that I am also come in the zone of consideration. Now, come to the page 19, my lord.
Yes.
Reservation policy. The promotion is to be considered in 80-20 ratio of APST and general category officer respectively. Now the total sanction code is 12. They have filled up all the total sanction code. Then where is the place of 20? 20%. They have not considered 20%. They have considered 100%.
If I understand, if I have understood correctly, the respondents are projecting that the two persons who were inducted were APST candidates, but they scored more than the reserve category candidates, and therefore they got this. In terms of
Yeah.
seniority.
All 12 posts have been covered by APST candidate. But as per a T20 ratio, 2 posts should be kept for general. Now, I'll show you, I'll make you satisfied. The first departmental promotion committee for a report, a recruitment rule is here.
Mr. Tapin?
No.
You have a copy of this OM dated 11/7/2002.
Yes, Lordship.
Where is that?
It's annexed in my Lordship.
Which page?
Yes, ma'am.
Yes, Mr. Patil.
This is 11 July 2002, Lordship. Annex is Annexure 5 in my epidemic.
Page,
Lordship.
page
Page 21.
21. Yes, Mr. Patil, please continue. Please continue.
Yes. Page 25. By promotion from the platoon commander, sub-inspector, Arunachal Pradesh, armed police, having 3 years continuous service in the grade of platoon commander, sub-inspector. And here also total post is 12. Now, then there is one notification. Come to the page number 26. This notification was issued on 15 October 2010. In the 1, 2, 3, last para of the third para, there is B, last para. In course, in case if it is found that either of the reserved or unreserved categories exceeds its ratio prescribed, the vacancy which has occurred in the cadre should be filled up either from reserved or unreserved category till the ratio of 80-20 is achieved. Now, 100, even maybe a promotion also, they cannot be promoted 20%, 100%. 20% reservation must be there. Now, in page 27, that is
No,
Nine.
but Mr. Patil, you see, I've told you the point of contention between you and the state is that the state's case is that this 20% was not filled up by APST people.
no,
Although they are APST, but they come in their own merit in terms of that OM dated 11/7/2002, right?
Correct.
So because you see, a person who is in reserve quota, if he scores more than the reserve category candidate, then he is transposed to a unreserved category and he occupies that post. Correct.
here also, my lord, it is also clearly written that if the total,
No, you see, there is a fundamental difference between you two. You are saying about quota. They don't say about quota. They said that once you score more marks than the reserve category, unreserved category candidates, you are transposed from a reserve category to an unreserved category and you fill up that post.
my point is that it is based on the post-based roster. Post-based roster.
Okay.
Now, in the come to the page 28, that
Page
page 28,
28.
yes, that reservation should be with reference to the post and not vacancies. And that representation of each of the reserved categories should not exceed the prescribed percentage of reservation. Now, now again, in page 29, para 4, it is axiomatic in service jurisprudence that any promotion made wrongly in excess of any quota are to be treated as ad hoc. This applies to reservation quota as much as it applies to direct recruit and promotee cases. Now, even in the recruitment also 80-20 ratio, and even in the promotion also 80-20 ratio is maintained. Then come to the, my lord, page 37, my lord. Page 37, this is the first DPC, an exercise. In the last, the DPC, after careful examinations of the vigilance, clearance, ACR and other service particular, and recommend the above mentioned serial number 1, 2, 3, 4, 6, 7, 8, and 9
You are reading which page?
for promotion to the rank of inspector.
Page number?
Page number 34.
34.
34.
Last paragraph.
Last para. Inspector in Arunachal Armed Police Battalion with the effect of the date of DPC dated on 13/8/2012 and the cases of serial number 5 and serial number 10 general will be considered in the next DPC. That means out of 12 posts, serial number 5 and serial number 10 has been kept for general quota. Then in the come to the my page 35. The page 35 last para.
Just a moment.
Huh?
Just. Yes, which page?
Page 34, 35.
35, yes.
And last sentence. The roster point number 5 and 10, which are unreserved, will be filled up on availability of the candidate from general category in their turn. Now, so post-based roster in maintained and it is prevailing in the recruitment rules. That's why they have considered it in their departmental first DPC, second DPC. They have mentioned clearly the quota. Then third DPC, page 36, vacancies position. Here also, posts are vacant against unreserved quota of roster point number 5 and 10. Since there was no general candidate available in the zone of consideration. Then That is page 36.
Page 36.
That is page 36. Now I come to page 37.
Yes.
Yeah, in here also, the DPC was informed that there are 12 sanction posts against Arunachal Armed Police Battalion by such and such and such. Out of 12 sanction posts, 10 posts are already being filled up. 2 posts are vacant due to retirement of 2 inspectors. Now the DPC has considered 2 posts to be filled up from the senior most sub-inspector among the eligible sub-inspector in armed police battalion. Here also, they have mentioned, as per the 100-point roster, 80% posts are reserved for APST and 20% for general. Then, here, while this DPC was held, at that time, both the petitioners were attend their qualifying service. They have crossed more than 3 years. They have already rendered. So, as per the recruitment rules, to get promotion, one must complete 3 years of regular service, and they have completed. But in spite of qualifying in service, their case was not considered. So they have filed the WPC 92 AP 2015. And this judgment was passed by directing that the promotion whom they have been given without considering the post-based roster, their promotion DPC was set aside and promotion was set aside. Here, in view of 29, in view of the foregoing discussion, and when established law laid by the Apex Court regarding the issue at hand, this writ petition is hereby disposed of by directing the state respondent to consider the cases of the present petitioner, Sri Anjan Roy and Sri Ananta Borua, both sub-inspector of Arunachal Armed Police Battalion, for promotion to the rank of the inspector in the next departmental promotion, DPC. Here, court has clearly given the direction, that clearly mentioned the name of the both petitioners, but when the DPC was held, they have not considered. That is in Annexure 1, page 18. Here they have not considered. They have considered the case of earlier respondent number 5 and respondent number 6. And present respondent number 6 and respondent number 7, respondent number 7 and 8, they have implicated themselves in WPC number 92 of 2015. They were implicated by themselves. But after cancelling that for DPC, because of the setting aside of those DPC proceedings and the promotion given to the respondent, they have constituted the big DPC, Departmental Promotion Committee. And again, though their promotion was set aside, DPC was set aside, but again, the same person has been promoted and without considering the 80-20 ratio. That is post-based roster. Now, what is my content on here? Case is that the this man who was passed in WPC number 90 of 2015, which was passed on 5/5/2017, attend finality. They have not made an appeal. They have not challenged. This judgment. And duty of the executive is to follow the court direction. Then executives are not the appellate authority of the court. When the court has clearly passed the order, setting aside the DPC, setting aside the promotion, how the same person has been promoted? And my case has not been considered. Then my prayer in this case is that first prayer is that DPC held on 27/8/2019 for the promotion of Sub-Inspector Arunachal Arms Police Battalion to the grade of Inspector under the chairmanship of Kalingkang IS Commissioner Home, Government of AP. Why it should not be set aside? Second, the response number 5 and quads. Now, a direction shall not be issued to the respondent authority to consider the case of the petitioner in terms of judgment and order dated on 5/5/2017, passed in WPC number 92/80 of 2015. Now, promotion order. The promotion order is in Annexure 13, page 52. This is the promotion order. On the recommendation of the DPC, dated 27/8/2019, the Governor of Arunachal Pradesh is pleased to promote the following sub-inspector to the grade of inspector, Arunachal Arms Police Battalion, in the level of 7 of the pay matrix of such and such and such. And those four persons were the party in WPC number 92 in 2015. They were the four parties. And though they have cancelled their appointment only for formality, they have cancelled their DPC and they constituted a new DPC. But again, in the same order, which was passed in fourth departmental promotion committee, they have given the same person in the promotion.
Where is this DPC dated 11/7/13? Which page? Page 36.
Oh, page 36.
6.
uh, page 36 is the, it is the third DPC.
Yes.
Page
By this, who was appointed?
Here my case was not considered because I was not attending the zone of consideration.
No. I have a reason to ask that. In page 36,
Huh.
it is stated that roster point number 5 and 10
Huh.
is not filled up. Roster point 5 and 10 is not filled up.
Yes.
Correct. Correct.
Yeah.
Now come to page 45.
Page 45, yes.
Para 16.
Yes.
What is this?
The state respondent had further contended that though the petitioner had completed the requisite length of service as sub-inspector at the time of the holding of the departmental promotion, dated on, sir, my lord, this is 10/11/2014. And the question where I have been asked is
No,
2013.
Please read that. Please read that.
Yes, 2014.
Please read. Continue reading. Please continue to read.
No. This is 2014 regarding to
Okay, please read.
14 also they were held department
No, please
DPC.
read this paragraph. Para 16, read it completely. Don't stop in between.
The state respondent have further contended, though the petitioner had completed the requisite length of service as sub-inspector at the time of holding of departmental promotion committee dated 10/11/2014. This is for DPC, but their seniority position were below Sri Tapokliti and Lingdum Komi as much as unreserved roster point number 5 and 10 were already filled up as per the recommendation of DPC dated on 11/7/2013, and as such, the cases of the petitioner were not considered by the DPC dated on 10/11/2014.
So was it filled up? 10/7, was it filled up? These two posts.
That's why they have filled up. Because of that order was set aside by the court. Court has set aside the DPC because they have not taken into consideration the 80-20 years old. In the recruitment rules also, they have mentioned the T20. Even in the DPC also, they have mentioned the T20. And even in the notification, 2010, it is clearly mentioned the T20. The inspector post cannot be filled up only by the PST. As per the recruitment rules, 20% goes to the general. But they have not mentioned it. And because of that, those DPC, which was held on 10/11/2014, was set aside and quiet.
Okay. Yes.
Yes, ma'am. Here, my lord, in the judgment, page 49, they have clearly referred the ruling also. That ruling is they don't have one. Yeah. Reservation, no. Post. The reservation has to be worked out in relation to the post, and the concept of vacancy has no relevancy. In the judgment itself, also, page 49, a judgment of the Supreme Court has been referred. This is in page 49, para 28. When a percentage of the reservation is fixed in respect of a particular cadre and their roster indicates the reserve point, it has to be taken that the posts shown in at the reserve point are to be filled up from amongst the members of reserve categories, and the candidate belonging to the general category are not entitled to be considered for his reserve post. On the other hand, the reserve category candidate can compete for the non-reserve post, and in the event of the appointment to the said post, their numbers cannot be added and taken into consideration for working out the percentage of the reservation. Reservation of appointment or post in favor of any backward class of citizen. It is incumbent on the state government under Article 16, subsection 4 of the Constitution of India to reach the conclusion that the backward classes for which the reservation is made is not adequately represented in the state service. When the state government, after doing the necessary exercise, makes the reservation and provides the extent of percentage of post to be reserved for the said backward class, then the percentage has to be followed strictly. The prescribed percentage cannot be varied or changed simply because some of the members of the backward class have already been appointed or promoted against the general seat. The fact that consideration numbers of members of a backward class have been appointed, promoted against general seat in the state services may be a relevant factor for the state government to review the question of continuing reservation for the said class, but so long as the instruction rules providing certain percentage of reservation for the backward classes are operative, the same have to be followed. Now, out of 12 vacant posts, all the 12 posts have been filled up by the APST candidate. Then in that case, it is clear-cut violations of the recruitment rule of 80-20. And we have been.
I don't know. This Sabharwal case, R.K. Sabharwal,
Yes.
cannot be read to mean that there is a reservation against unreserved category. Therefore, this 20% cannot be filled up from other castes. That I can't read. RK Sabharwal is for it gives protection to the reserve class, but it does not give protection to unreserved class.
And here, they are confusing about the post-base roster and seniority. The stand of the government is that my seniority is low, and I am not reaching. And whom they have been promoted, they are very much senior. My concern is that I am not concerned with the seniority. I am concerned with post-base roster. In a post-base roster, in the SI sub-inspector, the basis of appointment was 80-20. Now, why not? I'll be made 80-20 in the cadre of inspector. Therefore, the DPC conducted become very illegal and they have not taken into the consideration and their DPC is not consonant with the notification issued on 2010. Then it is not consonant with the wording of the first DPC, second DPC, and third DPC. Because in the first, second, third DPC, they have clearly mentioned that cell number 5 and cell number 10 is for the general categories. If I am not qualified, I was not qualified while the first DPC was held. I was not qualified while second DPC was held. I was not qualified while third DPC was held. So now I have already attained. I have rendered requisite service qualification. Now in this big departmental promotion committee, I am already attained.
Mr. Patil, you're not responding to the code query. You see, the code query was based on their affidavits. Is that even for a reserved post, unreserved category candidates can compete and get the posts. The only requirement is that they must score more than the reserve, unreserved category candidate. So that is stand of the state, is also the stand of Mr. Gini. Correct? So to this you have not responded. Huh? To this query of the court, you have not responded. If they are scoring more than the reserved category candidates, why the state cannot appoint?
Oh, that is my lord, that is direct recruitment case. But my case is a selection case. It is a selection. It is a promotion. When they have maintained in the 80-20 ratio in the recruitment, direct recruitment, there the question of scoring more or scoring less, the questions come. But it is a selection case. Promotion of a sub-inspector from SI to the inspector, it is a selection. It is a promotion. So when 80-20 is clearly mentioned, the ratio is mentioned in the recruitment rules. Even earlier DPC they have referred. Why they have not maintained it? Why they have paid it? That because of that, it becomes illegality and the DPC which was held on 27/8/2019. May be set aside any apart from the promotion order which was passed on 17/9/2019 should also be set aside and taking into the consideration of the judgment which has already passed in WPC number 92, 2015. Be taken into consideration.
Okay.
Court has clearly direct to give us promotion. But in spite of that, how they have not considered my case? And the person whose promotion is set aside, how he has been promoted again? That means the executive are above the court. Their attempt is by doing fraud, they try to nullify the court order. According to this DPC, the court order which was passed become invalid. They are not above the court. They should follow the court order. They should execute it. Instead of implementing the court order, they have nullifying the court order. This is the case, my lord.
Mr. Patil, this office memorandum of 11 July 2002 has not been challenged by you.
Then I have not seen, my lord. 2000.
Mr. It is in the affidavit in both affidavit of both the respondents.
Page 21.
Page 19 is also there,
Well,
filed by Mr. Genie.
Page 21.
huh?
2-1.
You see, clause 2, it speaks about cadre. It does not speak about direct recruitment or promotion.
Any issue immediate within the normal zone of consideration in the bidder grade. Such SC candidate cannot be denied promotion on the plea that the post is not reserved. Such such a candidate will be considered for promotion along with other candidates affecting him as if he belongs to the general category. In a case he is selected, he will be appointed to the post and will be adjusted against the unreserved point. Unreserved point. But my lord, here, this is not very much similar with our case. Our case is cadre. In a cadre, 80-20 ratio is to be maintained. Maybe in sub-inspector, maybe in the inspector. Both. Since post-based roster is basically only in the case of the promotion. Illegality is clearly appeared. And if I am not qualified, there is different thing. But they have in the DPC meeting and DPC proceeding, they have clearly written that all 20 sub-inspectors are attend the zone of consideration. That means out of 20, I am also one of them. Both the petitioners are also one of them. And the post was vacant. Then why, when the post is vacant, I am qualified. Why I have been deprived?
Let us see what Mr. Tapin says. Yes, Mr. Tapin.
Lordship, the judgment passed by the in earlier round of litigation, Lordship. Lordship, what I observe is, Lordship, state has its own policy, Lordship. As
No, you see, there are two things in the submission of Mr. Patil.
Lordship.
Number one, he says that the earlier order of the court was nullified. Because is that if it is then irrespective of the fact that he is below, the the reserve category candidate,
No, sir.
he is to be given promotion to fill up, to maintain that 20% quota for unreserved class.
No, sir.
Now, where is the DPC decision to promote him? Does this does it reflect the application of mind on that aspect?
Lordship, if Lordship see the consideration that has been made in the DPC, Lordship,
Where is that DPC? Where is that?
kindly come to page 14, my affidavit, Lordship.
Page 14.
Page 14, Lordship.
Yes.
Kindly come to next page, Lordship. That's page 15. Lordship, this is the seniority, Lordship, who comes under the Lordship zone of consideration, Lordship. Here, Lordship, in zone of consideration, Lordship will find the petitioner is one is serial number 8, petition number 1, and petitioner number 2 is serial number 11, Lordship. Both of them, Lordship, below the private respondents, Lordship, in seniority, Lordship. On merit, because they, Lordship, 3-person, this read petitioner and another 2 respondents, Lordship. In the same year, Lordship, they enter, Lordship. On merit, Lordship, these read petitioners are below the private respondent, Lordship. That part. Then may I take Lordship to the next page? That's at page 16, Lordship. Serial number 5, Lordship. This is how the DPC has considered their case, Lordship. The DPC further observed that serial number 1.
You see, his general submission is,
Okay.
let us say that the that one post, you just reverse the situation.
Lordship.
This post number 8 and 11. Let us assume that this whatever post you think of. See, let us say post number 1 and 2.
Lordship.
In roster based,
10.
is roster based, what you call this, reservation applies.
Lordship.
And the post number 1 and 2 is reserve category.
Correct, Lordship.
Correct. Now, in the selection process or in the seniority list, whatever way, direct recruitment or promotion, first 4 candidates are unreserved. In the gradation list or in the recruitment results, 4 persons at the top are unreserved category.
Yeah.
Now, please tell us that post number 1 and 2, which is for reserved category, how, according to you, will be filled up?
Lordship, that will be filled up among the Lordship, the reserve candidates, Lordship.
Reserve
The
category. So therefore,
top 2 will be Lordship
for reserved.
reserve.
Okay. But what happens to this unreserved people? 4 of them are there in top. What happens to them?
Lordship.
What happens to these 4 unreserved category candidates who are better placed or who are higher in the gradation list than the reserve category?
They will be placed in the Lordship, the
come down.
point at roster, Lordship.
They will come down.
Lordship, come down.
Correct. Why there will be a variation when it comes to unreserved category?
Lordship.
Why there should be a variation when the posts are earmarked for reserve category?
Lordship, here the post is the here unreserved, Lordship. The post earmarked for the unreserved category, Lordship.
So that's why I'm asking.
Lordship.
Now you are working differently.
Lordship.
In the first example, 2 posts are unreserved, 4 candidates are placed higher.
Lordship.
They are unreserved category, but they don't get the post because it is for reserve category.
Reserve category.
Correct. Now, what happens when it is reserved? When the post is for reserve category, then you have a different yardstick. Then you say that 4 people who are unreserved category gets the post. And the people who are, and if the post-based reservation is for reserved category candidate, they still don't get it.
Lordship, here the law is very clear, Lordship. Once the Lordship reserve candidate, Lordship, he Lordship compared with the Lordship unreserved
No,
category.
this is not competition. It's not direct recruitment.
Here, Lordship, R.K. Savarmal's case and this our office memorandum is very clear, Lordship, on this point, Lordship. If
But it can't apply to promotion.
it's about a promotion, definitely, Lordship. R.K. Savarmal's case also, Lordship, Lordship see. And our office memorandum also is very clear on the Lordship, is promotion, Lordship. If Lordship see the office memorandum, Lordship, at page 21, Lordship, the one, page 21, Lordship, the serial number 1, Lordship. The SC and ST candidates appointed by promotion on their own merit and not owing to reservations or relaxations of qualification will not be adjusted against the reserved points of the reservation roster. They will be adjusted against the unreserved points.
No, this will not apply because of the fact that in your, neither in your appointment, the promotional order, nor in the DPC, it has been clarified that these two will be treated as unreserved, reserved category, unreserved category.
Lordship, therefore, I was taking Lordship to the Lordship DPC consideration, Lordship.
Yes,
At page 16, Lordship,
yes, 16.
they,
Yes.
how they consider Lordship.
Yes.
At serial number 5, Lordship, the DPC further observed that the serial number 1, 2, 3, and 4 of the seniority list have to be given promotion keeping in view of the principle of intrinsic seniority. If they are picked otherwise, therefore, even though the petition number, petitioner
This can't
Anjan Roy.
happen. This can't happen. You see,
Yeah, may I
you
read
see-
that?
No. You see, please read in the context. Number one, you are first reading us, taking us to the office memorandum.
Lordship.
Office memorandum says he will be appointed to the post and will be adjusted against unreserved point. Correct?
Lordship.
So please, please show us that in the DPC, they took into consideration that the APST candidate who are promoted in a post which is roster-based reservation is for unreserved class. For all other purposes, they will be treated as unreserved.
That specific language is not there, Lordship.
Then it has
But
to-
here the consideration is that, Lordship, since the Lordship private respondents, Lordship, they are senior to the petitioner. Therefore, their cases
No,
are
but
need.
you will have to treat them as in some category.
So their
Post
cases,
the post is, you see, the post is unreserved.
post is unreserved, Lordship. But on merit also, they are, Lordship, above the petitioner,
They
Lordship.
treat them as unreserved, that you are not doing.
But that language is not there, but
No, no, but you
the
can't do it.
action is really very clear, Lordship.
No, it can't happen. It has to go.
Otherwise, Lordship, how the senior can be promoted? Otherwise, it will be amount to Lordship.
No, no.
Unreserved will be the amount to
Then-
reservation, Lordship.
You see, there is a procedure prescribed.
Lordship.
You follow your OM or you don't follow. But there can't be a via media, there can't be a alternative. If you follow this 11/7/2002, then it will be adjusted against unreserved point
Unreserved point.
that you have not done. So this
So
one.
this consideration, Lordship, that though that particular wording is not there, Lordship, but here
No, subsequent, you
clear
see,
indication has been given, Lordship.
you see not one, there are hundreds of judgment which says that reasons can't be assigned later on. The order itself must contain the reasons. By an affidavit or by an explanation, that reasons can't be imported.
But here, Lordship, one thing is admitted before this honor court. Lordship, the petitioner is genuine to the private respondent, Lordship. When that admission is there, Lordship, Lordship can take cognizance of that also, Lordship. Because on merit, Lordship, as I am submitted, Lordship, the private respondents are above the petitioner, Lordship. That is not disputed here, Lordship.
No, that means you see that reservation goes over 80% then. If you treat them as unreserved, sorry, reserved category, then the Ratio of 80-20 is not maintained.
No, because therefore they are being treated as lordship, unreserved lordship.
No, you have not
But
said
that
that.
language is not there, that is.
You have not said that. So
Lordship.
when 2002 is not complied.
Yeah. The strict sense lordship, that words are not there lordship, these posts where they are being promoted lordship, this is mean for lordship, unreserved, and therefore their post, the promotion will be treated as unreserved lordship.
No, what will, no, you see, if you don't treat them, if in the order you don't treat them as reserve category, then what happens when they become eligible for the next promotion?
That consequences, that I understood what lordship has observed, that I understood, that the ratio will be imbalanced, that's
80-20 can't be disturbed.
yes, that is their lordship. Only the
So
lordship.
if you are promoted on merit, what do you call an unreserved or a reserve category candidate to unreserved post, you must treat them as unreserved. Even for that reason, this order can't be sustained. You'll have to take a fresh DPC. And a fresh appointment order, you can place them higher if you want. But it has to be treated as he has to be treated. Mr. Gini's respondents, private respondents, they have to be treated as unreserved.
In strict sense lordship, that lordship, what lordship has observed, that's correct lordship. But 2010, DPC lordship, here lordship, this, another, because 5 and 10 lordship is unreserved lordship, point lordship. But here the private respondents are 4 lordship. So 2 persons are not lordship supposed to be disturbed lordship. That because petitioners are 2 in numbers lordship, but private respondents 4 are in numbers lordship.
No, because they have made all those persons who may be affected as parties. Otherwise, the writ petition would have been dismissed for non-gender.
No, what I'm submitting in lordship, this even if this DP is to be interfere lordship, to the extent of these 2,
5 and 10.
2 persons lordship.
5 and 10.
5 and 10.
Whoever is adjusted against 5,
Against the 5
whoever
and
is
10.
against 10.
Not the whole.
Not the others.
That's what I'm pointing out. Lordship.
No others.
Now my submission is lordship, if 6 sense, if that is not followed, then lordship, I have nothing to submit lordship, except for what I have submitted now lordship.
I understand. I understand. Mr. Gini?
Lordship, the law is very clear, Lordship, starting from Savarwal case, Lordship. Now, Lordship may kindly come to page 36.
Yes.
Regarding this DPC that was conducted on 11/7/2013, Lordship. From this DPC, it can be seen that, Lordship, roster point number 5 and 10 was filled, Lordship, by these 3 people. They are from reserve category, Lordship. 3 vacancy was still existing, Lordship. 2 was for unreserved. And these 3 people was filled, Lordship. So already filled by these 3 people only, Lordship. Now, whether these 3 people, they have retired or the seat that was occupied by these 3 people.
No, we are not touching any other post except 5 and 10.
Lordship, so why, Lordship? 5 and 10 fill up in this DPC, Lordship.
But this has to go. 5 and 10 were not filled up.
In the previous DPC, it was kept vacant, Lordship.
Yes.
In this DPC, Lordship, page 36, Annexer 8, Lordship. Here, the 5 and 10 was filled, Lordship. As per my plain reading of the DPC that was conducted, Lordship, 2 seats that was carry forwarded, Lordship, 5 and 10 that was carry forwarded, that was filled in this DPC, Lordship, particular DPC.
Just a moment. You see this, please come to this paragraph 16 of the earlier judgment. Page 45.
Lordship.
As it was filled up by recommendation of 11/7/13, that is why it was interfered with. Please come back to that 11/7/13. Which is that page?
36, Lordship.
11/7/13 is page 36.
Lordship, page 36.
Vacancies, the DBC was informed that there are 12 sanctioned posts of so and so, out of which 12 sanctioned, 10 was filled up. 2 vacant posts are reserved quota for number 5 and 10. Since there was no candidate available in zone of, now the DBC is considered to be filled up. And so, and therefore 5 and 10 are filled up. Three clear vacancies, including one who is retired.
Lordship. That would be reserved.
Where is that gradation list?
Page 21, Lordship, seniority.
Page 21.
Their name are not here, Lordship.
Just a moment, page 26. Coach Laling.
This is incomplete seniority list, Lordship. It's not a complete.
This is final seniority, page 21, final seniority list as on.
This is of sub-inspector, Lordship. Second November 2011, Lordship.
1/9/2010. 1/9/2010, page 36. The person who is retired is Coach Laling. And there were 3 posts. Godak Taza is one. His name is a serial number.
Lordship, this is the seniority list of sub-inspector, Lordship. Like Coach Laling will be in the post of inspector, Lordship. So the seniority list.
No, these sub-inspectors are promoted to inspector. This serial number 1, Godak Taza, where is his name in this seniority list?
It's not there, Lordship.
It's not there.
It's not there.
Second is Taring Padung.
Taring Padung, Lordship. He's also not there.
He's not there.
Marto Bam, Lordship. He's also
Marto Bam, he's not there. So when did their name come in the seniority
They
list?
must be more senior to Tapok Bitting and Lordship. The serial number 1.
No, it can't be. His final seniority list. Page 21 is final seniority list.
Maybe they had a earlier seniority list before
No, it can't be.
2011, Lordship.
When it's a final seniority list, everybody who is howsoever high will come in that list.
I don't know, Lordship, why they have not.
There
added
can't be
their
2
name.
final seniority lists for same cadre.
Maybe their name was removed from this since they were promoted to
It can't be
inspector.
removed.
Maybe they,
That's not a final seniority list. If they are removed, they are out. They couldn't have been appointed.
Maybe they were appointed, promoted, so why their name must have been omitted.
Those theories don't come in. This is a seniority list of 1/9/2010. This DPC you are saying appointed them 11/7/2013.
13.
So they could not have been off-listed before 2013.
Now this, Lordship, point number 5 and 10 is occupied by among these three people, Lordship. Simply said to consider the case of the petitioner at that point of time, Lordship. Since they were coming under the zone of considerations, Lordship. So they were not considered at that point of time. So their case was to be considered. Accordingly, it was considered. They were brought under the zone of consideration, Lordship.
Yes, Mr. Patin, then we have a question for you. Mr. Patin, we have a question for you. This para 16 of the High Court judgment.
Oh, yeah.
Two roster point 5 and 10 were filled up as per recommendation of DPC dated 11/7/2013. Neither these DPC minutes of 11/7/2013 nor the appointment orders of those persons who had filled up the roster point post at roster point number 5 and 10 are under challenge.
Yes.
The High Court in this order at page 40 has merely directed the authorities to consider both of you, Anjan Roy and Ananto Barua, for promotion in the next DPC. But if this roster point 5 and 10 are filled up,
Yes, madam. Next DPC means 11, 10, 11, 2014 DPC, they actually, it was challenged. Now, the present DPC, which was held, it was on 27/8/2019.
no, you are not getting the point. Mr. Patin, the
Huh?
point is, if paragraph, if the observation of this court in paragraph 16 at page 45 is correct, then roster point number 5 and 10 posts were filled up by the recommendation of DPC dated 11/7/2013. If the post is filled up, there doesn't exist, this vacancy does not exist.
No, my lord, as per the notification, 2010 notification, there cannot be, post cannot be taken away. If any categories, either reserved or unreserved, if they fill up the post, it should be always stated as adopt.
Oh, no.
Yes,
No, we'll respectfully
It says-
disagree with you. You see,
the,
please come to page 15. The
uh,
DPC recommendation and the orders of promotion pursuant to DPC is not under challenge. You please come to para 16, page 45. Roster point number 5 and 10 were filled up by recommendation of DPC dated 11/7/2013. Neither those appointment orders nor the DPC resolution of recommendation of 11/7/13 are under challenge.
13.
Please see para for
No,
page
no.
45,
Yeah.
page 45, para 16.
Uh,
Both these are not under challenge.
no, my lord. 11/7/2013, I was not qualified. And the DPC who was held prior to that, I was not qualified. Since 2010, 11, 2014, I attend qualifying.
I'll give a simple example. My examples are horrible, so therefore please excuse me,
2012.
Mr. Patin.
Huh.
My examples are always horrible, so forgive me for giving a horrible example. You see, there is a post of principal which is vacant. A was not qualified on 1/1/2023. On 2/1/2023, that post was filled up. On 3/1/2023, A gets qualification. Now, without setting aside the appointment of B, can A be given the post after he makes a qualification?
Even maybe fill up also, post will not go. Because.
So
the
there will be two
access-
principal. Principal number one,
The category who is not deserved to the post,
that can't happen.
his promotion will be treated
No,
as
no,
an ad hoc.
No. We can't agree to that because
Well-
once a post is filled up, it is filled up.
Here in the NSR 4, 5th October 2010 notification, it is elaborately clearly written.
No, nobody prevented you from challenging that appointment. You did not do so. You could have challenged the appointment and the DPC resolution by saying that
2012, there was DPC. Though we were not qualified, but they have clearly mentioned serial number 5 and 10. And 13 also they have mentioned.
no.
But that time we were not in qualifying service. Since we are not qualifying in service, we cannot. But they cannot change the post-based roster, which is already notified in 2010. This is their executive departmental action.
I did not.
Can they make
See,
very clear
Mr.
notification
Patil,
circulated by the state?
before I became a lawyer, I was not aware of the principles of waiver and estoppel. Somebody was appointed, you waived your right to challenge it. Now you're hit by the principles of estoppel. Once those poster 5 and 10 are filled up, acquiescence, these things, unfortunately, I learned in the profession. So you'll have to wipe out my mind with the feelings of those three words: waiver, acquiescence, and estoppel. Once that post is filled up, and that is in the order of this court, I can't review that order.
As per the Sabharwal versus State of Punjab, there, even it may be fill up also, the reserve quota will never go. But that promotee or the appointee will be treated as always on ad hoc, not regular. Until and unless his turn come. The moment his turn come, then his service will be regularized. And by way of fill up that post, vacant post, can they nullify the notification, state notification issued for governing entity of the state? And can they change the recruitment rules? Even in the recruitment rules also, it is clearly written 80-20. Instead of writing 80-20 in the recruitment rules, can I make 100% appointment from particular reserve category? Then it still will be illegal. So here 12 sanction 4, all 12 sanction 4 have been filled up by the APST. Whether we will take it, it has been done as per the recruitment rules. So law cannot be adjusted as per who am sovereign executive.
Okay. Yes, that's all.
Yeah.
The posts were filled up, you are saying. Five
Lordship,
and
the post was
5
already
and 10.
filled up.
Filled up by this. Filled up
Among
by
these
whom?
three people, Lordship.
Huh?
Among these
No,
three.
these three people.
Three people. That was not put to challenge.
Okay. Heard. Mr. M. Patil, Leonard, Senior Counsel, assisted by Mr. Pardon me?
MUB.
M. Ube. How do I spell it? Learned Counsel for the petitioners. Also heard Mr. S. Tapindranath, Senior Government Advocate, appearing for respondent numbers 1 to 4. And Mr. J. Gini, Leonard Counsel, appearing for private respondent numbers
5, 7,
5
and
to
8.
8.
5, 7, and 8. 6,
5, 7, and 8.
Lordship.
None appears on call for respondent number 6, on whom notice was served in a substituted manner by publication of notice in the Arunachal Times edition dated 3 May 2023. Next paragraph. The petitioners are serving as sub-inspectors in the Arunachal Pradesh Police Battalion, within brackets, AAPB small n, for short, bracket closed. So based on the final seniority list of sub-inspectors in AAPBN, it is projected that the names of the petitioners appear at serial number 9 and 12 respectively. To stop. It is projected that as per the no, as per the provisions of Subedar, SUBEDAR within bracket inspector AAPBN Group B gazetted within bracket non-ministerial bracket closed recruitment rules, 2008, a sub-inspector of AAP battalion having 3 years of continuous service in the grade of platoon commander is eligible for promotion to the post to the next higher post of inspector. In this, Mr. Patin, in this recruitment rules, page 23, where is the 3-year prescription? Which clause is that 3-year prescription?
Page 25.
20?
25.
25.
Column 12.
25,
Column 12.
column 12. By promotion from the platoon commanders or under the sub
Three
inspector.
years, 3 years continuous service in the grade of platoon commander within bracket sub-inspector. The learned senior counsel for the petitioners has submitted that as per office memorandum dated 15/10/2010, the post of inspector of AAPBN is required to be filled up from reserved or unreserved category in the ratio of 80:20. Accordingly, it is submitted that the said ratio in respect of the cadre of inspector has to be maintained at all times. It is also submitted that previously 100-point roster was maintained for the said cadre, but consequent to the judgment of the Supreme Court of India, in the case of R.K. Sabharwal, Sabharwal, and others versus State of Punjab and others, within bracket 1995, bracket close 2 SCC 745, the state government had notified office memorandum dated 15/10/2010, and the 100-point roster was replaced by a post-based roster. Amongst unreserved and reserved category candidates, if there is an excess representation of any category, it is required to be adjusted in the future recruitment. Full stop. Next paragraph. The Learned Senior Counsel for the petitioners has referred to the Departmental Promotion Committee minutes held on 13/8/2012, wherein it is mentioned that the posts of inspector at roster point number 1 to 4, 6 to 8, and 9 were reserved for Arunachal Pradesh Scheduled Tribe, within bracket APST for short, bracket close, candidate, the posts at roster point number 5 and 10 were for unreserved category. Full stop. Accordingly, as no suitable candidate from unreserved category was found available, it was recommended that the roster point number 5 and 10, within bracket general, would be considered in the next DPC. Full stop. The subsequent DPC was held on 9/1/2023 and in the said exercise, the posts at roster point 5 and 10 remained unfilled. And it was recommended that the unreserved post will be filled up on availability of candidate from general category in their turn. Full stop. Next, thereafter, another DPC was held on 11/7/2013 to consider promotion of sub-inspector to the rank of inspector in AAPBN and as no general candidate was found available in the zone of consideration as per seniority list in respect of roster point number 5 and 10, the DPC had recommended the said two posts to be filled up from the senior most APST sub-inspector for promotion to the rank of inspector in AAPBN. Full stop. Moreover, one vacancy arose due to retirement. One vacancy arose in the post of inspector in AAPBN due to retirement of one inspector on superannuation on 31/5/2013. Full stop. Accordingly, in respect of 3 clear vacancies, the name of 3 persons were recommended. Three persons in the rank of sub-inspectors were recommended for promotion to the rank of inspector in AAPBN with effect from 11/7/2013. Full stop. Next paragraph. On a query of the court, the learned senior counsel for the petitioners had submitted that on the date the DPC dated 11/7/2013 was held, the petitioners did not have 3 years of continuous service in the grade of sub-inspector. In this regard, we may refer to this statement made in paragraph 10 of the writ petition, where it has been mentioned that the petitioners were appointed on 1/9/2010, and therefore they attained 3 years of continuous service in the grade on 1/9/2013. And it is further mentioned that the case of the petitioners for promotion to the rank of inspector as per post-based roster was not considered in the said 3 DPC held on 13/8/2012, 9/1/2013, and 11/7/2013 on the ground that the petitioners have not attained 3 years of continuous service in grade of sub-inspector, and the petitioners have no grievances at that relevant point of time. Full stop. Next paragraph. Another DPC was held on 10/11/2014. And though the petitioners had the qualifying service of 3 years on 1/9/2013, but their case was not considered. Accordingly, the legality of the promotion given to the respondent number 5, namely Sri Tapok TAPOK between DITIN, and respondent number 6, namely, Sri Lingdum LINGDUM Komi KOMI. In the DPC held on 17/10/2014 was assailed by the petitioners by filing WPC 92 within bracket AP / 2015. Mr. Tapin, Mr. Jini, and Mr. Pertin, please correct me if I am wrong anywhere. Correct? This court by judgment and order dated 5/5/2017 allowed WPC 92 AP of 2015 by directing the state respondents to consider the cases of the petitioners, namely Anjan Roy, Sri Anjan Roy and Sri Ananto ANTO Boruah BORUH, both sub-inspectors of AAPBN, next DPC without fail. Was citizen inquest. Next paragraph. Consequently, the promotion given to the respondent numbers 5 and 6 was cancelled by order dated 1/4/2019, so, however, the names of the private respondent numbers 5 to 8 were once again recommended for consideration in the next DPC, which was held on 27/8/2019, and based on the recommendation of the DPC, comma, the respondent numbers 5 to 8 were appointed as inspectors in AAPBN against the post-based roster without considering the case of the petitioners. So accordingly, by filing this writ petition under Article 226 of the Constitution of India, comma, the petitioners have assailed the DPC held on 27/8/2019 for the promotion of sub-inspectors in AAPBN to the grade of inspector within bracket AAPBN and the petitioners have also prayed for setting aside the promotion order dated 17/9/2019 in respect of respondent numbers 5, 6, 7, and 9 and for further direction upon the respondent authorities to consider the case of the petitioners in terms of the judgment and order dated 5/5/2017 passed in WPC 92 AP of 2015. Next paragraph. The learned senior counsel for the petitioners has submitted that once the roster point number 5 and 10 posts are earmarked for reserved category, unreserved category, comma, those posts cannot be filled up with candidates from reserved category and therefore the cases, the case of the petitioners would have to be considered for promotion under the roster point as earmarked at serial number 5 and 10 in the cadre of inspectors. Full stop. In support of his contention, comma, the learned senior counsel for the petitioners has placed reliance on the judgment of the Supreme Court of India in the case of R.K. Sabharwal within bracket Supra, which is reiterated. The relevant paragraph thereof is reiterated in para 28 of the judgment and order dated 5/5/2017 passed by this court in WPC 92 AP of 2015. Next one. it is further submitted that notwithstanding that the posts which were filled up by pursuant to DPC recommendation made on 11/7/2013, as the petitioners have now come within the zone of consideration, their cases are required to be considered. Notwithstanding that those appointments were not under challenge. Next one. Closing the prayer made in the writ petition and contention of the learned senior counsel of the petitioners. The learned senior government advocate as well as the learned counsel for the respondent numbers 5, 7, and 8 have submitted that the posts under roster point number 5 and 10 is admittedly filled up by recommendation of the DPC held on 11/7/2013. And that on the said date of 11/7/2013, neither the petitioners had the requisite qualification of 3 years of continuous service in the post of sub-inspector in AAPBN and not on attaining the requisite on obtaining the requisite qualification of the tenure of service of 3 years, the appointments so made in roster point number 5 and 10 were challenged. The petitioners cannot challenge the recommendation and appointment of the private respondents to the post of inspector. Next. In Mr. Patil's submission, he also relies on the decision of the Supreme Court of India in the case of Mangatram, MENGAT, Mangatram versus State of Punjab and others. 2005, 9 SCC 323. By submitting that in the said judgment it is settled that the reservation has to be worked out in relation to the post, and the concept of vacancy has no relevance. Next one. So the court finds that in the judgment and order of this court dated 5/5/2017, passed in WPC 92 AP of 2015. In paragraph 16, there's a categorical finding to the effect that the unreserved roster point number 5 and 10 were already filled up as per the recommendation of DPC dated 11/7/2013. And as such, the cases of the petitioners were not considered by the DPC dated 10/11/2014. Mr. Tapin, is there anything on record? I read it somewhere, but I missed it. After 11/7/2013, what is the date of orders? 11/7/13 DPC. After that, what is the date of appointment order? There is somewhere I read it, but I'm missing it. 11/7/2013 is the DPC.
Yes.
What is the date of appointment? It's mentioned somewhere. Okay, just forget that. Next paragraph. Be that as it may, it is the admitted case of the petitioners that the fourth that after DPC dated 11/7/2013, the next DPC was held on 10/11/2014. So therefore, in all probability, the posts at roster point number 5 and 10 can safely be presumed to have been filled up prior to the DPC held on 10/11/2014. Full stop. Next paragraph. The petitioner has filed the earlier writ petition in the year 2015 . Earlier writ petition, that is WPC 92 AP of 2015, the year 2015. And they said writ petition was decided by judgment and order dated 5/5/2017. Full stop. This court in the said judgment and order dated 5/5/2017, had not interfered either with the DPC dated 11/7/2013 or interfered with the appointment made in the posts covered by roster point number 5 and 10. Although the same was filled up by a non-APS, purportedly by reserve category unreserved category candidates. Full stop. Therefore, the next part, therefore, the persons who have already been appointed to roster point number 5 and 10 pursuant to DPC dated 11/7/2013 cannot be adversely affected by any order passed by this court in the present writ petition. It is not the case of the petitioners that any of the private respondents herein were appointed to the posts covered by roster point number 5 and 10. Therefore, the appointments, the selection and appointment of the petitioners to the post of inspector by the DPC held on 27/8/2019. Full stop. Nonetheless, by following the directions contained in the case of R.K. Sabharwal and others within bracket Supra, the state government it's concerned departments, including the Home Department, will be required to do an exercise so as to work out scheme so that without disturbing the appointment which has already been made, the posts at roster point number 5 and 10, which is meant for unreserved class, shall have to be carved out so as to maintain the ratio of 80:20, which is the prescribed ratio as per the recruitment rules, as modified. Wide notification dated readjusted. The same has to be done to provide the extent of reservation as envisaged under the recruitment rules, i.e., sub-inspector, sorry, Subida within bracket inspector, APBN so and so, rules 2008. The extent as modified by notification dated February 2008, bearing number PHQ public. What is the number? I can't read this notification number, page 23.
From down below.
Oh, no, not modified, not modified. No, that reservation has come where, roster point? This is the recruitment rules. 20 February 2008 is the recruitment rules.
Section 3 is the recruitment rule.
The recruitment rules, not modified by notification.
Recruitment.
Huh?
Recruitment.
No, this, what you call roster point, where is that? This is page 26. Is it page 26?
This is the office member.
This is the one.
This is the office memorandum, Lordship.
No, that reservation of 5 and 10 roster point, where is that?
The roster, that roster has not been annexed here.
It's not annexed.
It's not.
Oh, okay. Full stop. But this will lead to a situation where when the petitioner becomes qualified, he'll be fitted in that roster point on the date he becomes qualified.
The total sanction post is only 12 Lordship.
No, I
And next,
understand.
next will come at 15 and then 20 Lordship. Even if they have to be considered.
No. Whenever the vacancy arises,
Lordship.
the petitioners will have to be fitted in. They can be only fitted in at roster point number 5 and 10.
5 and 10.
So even if it requires some jiggling, it has to be done and they have to be accommodated.
But this correct. The persons who have been filled up at the roster point at the 5 and 10
They
Lordship.
have to be disturbed.
Yes, if they Lordship, because they have been accommodated on their own merit Lordship.
I understand, but the reservation is eaten up.
Lordship.
So the reservation has to be carved out for them. For unreserved category, 5 and 10 will be made free for them. Full stop. Therefore, in the exercise to be done, if the, Mr. Tapin, please hear it, huh? If the authorities find that that for any reason whatsoever, the posts at roster point number 5 and 10 fall vacant, either by promotion or death of any of the other incumbents in the gradation list of inspectors, the said posts shall thereafter be filled up strictly in terms of the reservation policy of the state at the ratio of 80:20 amongst the reserved and unreserved category. And if the petitioners are found to be in the zone of consideration, on the date those posts fall vacant, the state respondents shall consider the candidature of the petitioners for filling up the posts of inspector at roster point number 5 and 10. Full stop. Next paragraph. Accordingly, the writ petition stands partly allowed. Full stop. For the sake of clarification, it is provided that number 1, that the appointment of the private respondent numbers 5 to 8 are not interfered with. Number 2, the posts at roster point number 5 and 10, which were already filled up by DPC dated 11/7/2013, are not interfered with, as the petitioners were not qualified on the date of DPC to be promoted to the post of inspector. Number 3, if for any reason whatsoever, the posts at roster point number 5 and 10 fall vacant, the state respondents in the Home Department shall scrupulously follow the reservation policy, and the said posts shall be filled up by persons from unreserved category. Number 4, in the event the posts at roster point number 5 and 10 for vacant, the case of the petitioners for promotion shall be considered by the DPC. Next one. Before parting with the records, the court hopes and trusts that the state government will consider the situation in the present case and take an appropriate decision as to whether there is a possibility of Mr. Tapin, all these 12 posts are not filled up.
It's already filled.
All filled up.
All.
Only they are not required.
At 5 and 10 also. Future vacancy arises, the persons who have filled up these 2 posts.
Okay, they're not required.
Then only their cases can be considered.
Okay. This one.
All right.
Then, my lord, I am raising the maintenance of this writ petition, my lord. Yes, writ petitioner, otherwise also this matter has become infructuous, my lord. Yeah. Lord,
Why?
Your Honor, I'm. May I, my lord? My lord, may.
Yeah, against steps.
Yes,
Against respondent number 5.
yes, it's it is not found. It's this.
It's
So-
causing us trouble, my lord. Respondent number 5 is not a necessary party here, my lord. Respondent number 5, my lord. It's not a necessary
No,
party.
whether necessary or not, that we are not deciding. We have not put him to notice to say whether he is necessary party or not.
My lord.
Do you give an undertaking that if we struck out the name of respondent number 5, you as well as the state will
Scheme,
not
my
take
lord.
any advantage of that situation?
A scheme has been sanctioned by the
No, no,
NEC.
I understand, but you see, you are asking for striking out
My lord.
as not a necessary party.
My lord.
Are you prepared to give an undertaking that if name of respondent number 5 is struck off, neither you nor the state
My lord.
shall take a defense of non-gender of necessary party?
I will try to convince your lordship with indirect way. My lord, may please come to page 9.
Just a moment. Okay, end of the matter, service report is there. Please make it a habit. You are young people, you should have a habit of reading at the court record. Okay, let me dictate the first part of the order. Mr.
Entaro.
S.
Entaro.
N. Tharo, counsel for the petitioner is present. Petitioners is present. Stop. The Miss Learned Government Advocate representing respondent numbers. Respondent number 3. Who is Rural Development
I
Department?
am for 124, my lord.
Okay, and
Study course.
Mr. B. Pichal, Learned Standing Counsel for the respondent numbers 1,
2 and 4.
1, 2, and 4. Oh, you say I heard Swenso as well as Swenso. Next para. As per the as per the office note dated 13/7/2020, 13/2/2024, comma, service report in respect of respondent 5 is returned back from the registry of High Court of Meghalaya after causing service. Full stop. None appears on call for the respondent number 5, although notice is duly served. Yes, on which date did you raise the question of maintainability?
On my lord, last to last occasion, my lord, it has not been recorded, my lord. But I have raised the issue of maintainability on.
No, there is no order questioning the maintainability. Last it was listed on 21/6.
Alright.
The petitioners are yet to file the rejoinder. Notice on respondents are complete. This is the matter for admission.
Yes, ma'am.
There is no order of maintainability. We must put him to notice to address the court on maintainability.
My lord, even though, my lord, since the matter is listed for.
No,
admitted, my lord,
In admin, he must have noticed. You seeing a young large standing here.
my lord,
You can't hear him on the issue of maintainability.
my lord, yes, yes.
Correct.
Can it be, my lord, day after tomorrow, my lord, because we are having tremendous pressure, my lord,
Okay.
on the issue of maintainability. My lord.
Day after tomorrow.
Day after.
Be ready with maintainability. Correct. Even if your senior is not there, you will be prepared for arguing. Correct. Will you acquire courage by then?
Your Honor, Lordship.
No, I am asking you a question.
Yes.
If it is listed day after tomorrow, can you muster courage, acquire courage and argue the matter day after tomorrow?
Senior will come. for
Yes,
argument.
you still don't have courage. Okay. The Learned counsel for the Rural Development Department has raised a question of maintainability of the petition. Accordingly, the matter stands adjourned today by putting the petitioner to notice to respond to the issue of maintainability. Next for a list on day after tomorrow.
19, my lord. 19.
All right.
Obliged, my lord.
Is your
Yes.
lordship, an IA has
Yes,
been
Mr. Nair.
filed for impediment, my lord. So in that, my lord, notice has not been issued. Notice may be issued, my lord, and we may be given some time to
Okay,
file. our
you
objection.
are
And for the.
Yobin Welfare Society. Yes,
Yes, my
you
lord,
are
it's
there.
for the-
Am I audible, my lord? I am online appearing.
Yes.
Yes, I am appearing for the applicant, my lord, in the interlocutory applications, my lord.
Yovin Welfare Society.
Yes, my lord.
Yes. Okay. You're opposing the.
My lord, I'll have to take instructions on that, my lords. Because we
Oh,
are
okay.
claiming our traditional rights.
Okay. You write the order in IA Civil 146. Heard, mister, your name is P. Yovin.
Yovin, my lord. P. Yovin.
P. Yovin, YOVIN. Learned counsel for the applicant. Also heard Mr. P.D. Nair, learned counsel for the opposite parties who are the writ petitioner in the connected writ petition. First of all, this interlocutory application has been filed for the implement of the applicant as one of the respondents. Respondent number?
11, my lord.
Respondent number 11 in
12,
the
12, I'm sorry.
connected-
Respondent number 12.
12 in the connected writ petition.
No.
Full stop. Next, for the learned counsel for the opposite party submits that he would like to obtain instructions and respond to the application. Next, para, accordingly, issue notice on this interlocutory application, which is made returnable on.
My lord, could it be 4th of November, my lord?
That is
4th
too
of-
long.
My lord, after the vacation. Because we'll need to search out the old records, my lord.
On which date? 4th of November.
4th November.
Notice on this also. Notice is made returnable on 4/11/2024. Next para, list on 4/11/2024.
Well, it will be
Objection, if any, be filed at least 2 days prior to the next date of the same.
My lord, it will be respondent number 13, my lord. Implement as respondent number 13, not
13,
12.
not
1
12,
3, my
13,
lord.
1 3.
My lord.
Okay, but you are also required to address us on maintainability.
My lord, that they have already sought time to file their affidavits. They have not filed their affidavits.
No, without even affidavit, the
My-
maintainability is already a
My-
question raised.
That can be addressed on 4th of November. my lord.
Okay. Deeply, just let me pass an order on that. In the writ petition you like, Mr. P.D. Nair from the counsel for the petitioner. Mr. Kato is there? No.
He was here, my lord, in the morning.
Okay. Mr.
L Rockup. L Rockup.
L.
L Rockup.
You have the spelling. Learned counsel appearing on behalf of Mr. M. Kato, learned DSGI. Miss K. Wangmo, learned government advocate appearing for the state. 2, 4 and 6 to 12. And Mr. who appears for Mr. Kamduk?
Mr. Kamdup was here, my lord, in the.
Mr. D. Kamduk, learned standing counsel for land management department.
5. 5.
Next paragraph. Also, it's a to notice that by an order dated 9/4/2024, this court had provided that the issue of maintainability as raised by the learned additional advocate general shall be considered on the next date. Accordingly, on the next date of listing, amongst others, comma, the issue of integrity shall also be heard. Next list on 4/11/2024.
Deep. Obliged.
May I beg your lordship?
Yes,
This is a tender matter, your lordship.
yes.
And on 18/6, your lordship, 18th of July, this matter was listed. And this honorable court had verbally directed the department to seek instruction as to what has to be done with regards
Which
to
department?
RWD, your lordship.
What is the work?
This is
Well,
for
it is
the
construction of
the
road.
your lordship.
Construction of road.
Yes, your lordship.
Why should we continue with this stay?
This is what, your lordship, my only humble prayer was and is in this case, your lordship, is let me participate in the tender, your lordship.
No, that's not so easy. You have to tell us what is the ground.
Don, your lordship, I kindly come to page number 28, your lordship. To 8, your lordship. These are the dates on which the tender was published and the last date for submission of the bids, your lordship. Serial number 4, your lordship. From 20th to 3rd of April, your lordship. These are the dates, your lordship. Subsequently, your lordship, may kindly come to page number 131, your lordship, my annexure D.
Mr. Mr. Tarak, in this case, the date was extended to 10/4. Correct.
Yes, as for their
After 10/4, you preponed it to 3/4.
3/4, your
3/4.
lordship.
Then you'll have to give him time to participate.
No, your lordship, they,
But my lord, otherwise, as per record, 3/4 was last date for opening.
You see, did you or did you not issue a corrigendum fixing a date of 10/4?
if your
That corrigendum itself, now that incumbency executive engineer, now he has been transferred.
No. That's not the point. The point is that the petitioner projects that there was a corrigendum on 10/4. Which page?
Yes.
on 2nd April
Which
2024,
page? Which page?
page number 131, your lordship.
131.
Yes, your lordship. Why this corrigendum, your
Just
lordship?
a moment. Let us get to that 131.
131 annexure D, your lordship.
131. This is
Yes.
corrigendum.
Yes, they extended the date to 25th of April, your lordship. From 3 to 25th, your lordship.
25th.
Yes, your lordship. Then what they did, your lordship, the next page, your lordship, page number 132, your lordship. The impugn, your lordship. In this corrigendum, your lordship, the last line, your lordship. The technical bid submitted later than 3rd April will not be accepted, your lordship.
That could not have been done.
This is
No,
what-
131 is something different. The date of opening was start. It will be open after election, it says. By that time, they have they must have upload.
My record, your lordship.
Unless
is
you
pretty-
deny the correctness of this corrigendum dated 2/4/2024,
Yes.
let me allow him to participate. Otherwise, the stay would be extended.
Otherwise, before by second, he has to upload all the documents. This order was issued on
Your lordship may come to
Second.
page number 138, your lordship.
Sir, we don't know. I have absolutely no access to your department. I don't know how they work.
that in case of,
Here is a document at page 131.
yes.
If you don't deny the correctness of this.
And it is not a fact, your lordship, that I did not approach the website also.
I'm speaking for you, Brett.
Obliged.
Don't participate again.
That in case of this one package, Nyogring to Pilov, that was the tender which was put.
No, you see, whatever date you have given.
Yes.
But if you have extended the time, even if he is not wanting to compete, let us assume that he is, what you call, in English we call it STOOG, STOOG. They appear for third parties, even if he is that unwanted man. But is this 2 April 2024 is right or not? If it is right, if it is there, then when you postpone it, you accept his tender.
Then in case of this package, then it has to be go for fresh tender. Otherwise, if it is already uploaded, he cannot be allowed. There is already website is.
No, we'll set aside everything.
In case of one package, that is which is claimed.
Yes. In respect of this case only, not for others.
Not others, yes. According to Pilop.
He is not asking to participate in all these tenders.
No, Your Lordship.
Only one.
Only one. Your
Which one? At page 131, which is the contract?
Page 28 is
No,
NIT.
page 131, which is that
Yes, Your
contract?
Lordship, I am coming. Serial number 14, Your Lordship.
Serial number 14.
Yes, this one.
Construction of road from
Nyokoriang to
Nyokoriang
Pilop.
to Pilop.
Yes, Your Lordship.
You take instructions over phone.
Yeah.
Now, if they agree, we dispose of the matter. Otherwise,
Lord-
when we extend the stay, it goes for other 2-3 weeks.
Let it be tomorrow. Tomorrow. I'll take instruction.
Tomorrow?
Yes.
Not tomorrow, day after tomorrow.
Day after tomorrow.
That's
Your
all.
Lordship.
Okay. Your name, Mr.
T. Sering, Your Lordship.
Mr. T. Sering,
Yes, Your Lordship.
learned counsel for the petitioner, has drawn the attention of the court to a corrigendum dated 2/4/2024, by which the tender scheduled to be opened on 3/4/2024 was postponed to be opened on 25/4/2024 at 11:00 hours. And it was further provided that the tender submission end date will be extended till 24/4/2024 at 16:00 hours. No, not 1600 hours. First of the said corrigendum, amongst others, is in respect of the tender for construction of road from Nyokoriang, Nyokuriang, TO2, Pilop, PILOP, within bracket, AR/14/02/096, bracket closed. Full stop. However, by a corrigendum, another corrigendum dated 10/4/2024, you see that this 2/4/24 earlier one, full stop, the said corrigendum dated 2/4/2024 was issued by Executive Engineer, Rural Works Department, line LAAYING, Yangte, YANGTE. Stop. By another corrigendum dated 10/4/2024, issued by Executive Engineer DPIU, within bracket P. Three 4/2024 was cancelled, and it was notified that technical bids submitted later than 3/4/2024 will not be accepted. Full stop. Next, in this regard, Mr. G. Tarak Lanet, standing counsel for the RWD, prays for his granted time to obtain instructions. Next, for a list on day after tomorrow is 16, 20 September.
Highly appreciated, Chief.
What is this mean?
My lord, I was, since this morning, I was making mentioning of this matter on behalf of N-Pada. Due to some domestic issue, he could not be appeared before this court. And I have got the instruction that he will be filing rejoinder against the affidavit in opposition filed by the respondent.
Okay, okay,
List after puja vacation.
okay.
And there is an interim order,
On
my
the-
lord.
on the prayer made by Mr.
B. Kamdak on behalf of N-Pada.
B. Kamdak,
Yes.
learned counsel for the petitioners from a list after 2 weeks so as to enable them to file affidavit, rejoinder affidavit.
Rejoinder.
Full stop. Interim order passed release stands extended till the next date of listing. You say one last opportunity to file rejoinder. Is last opportunity to file rejoinder.
Deeply obliged.
Last opportunity.
My lord,
Yes,
yeah, I was supposed to file rejoinder has been filed. Yeah. So, pleading part is completed.
pardon me, I'm not getting you. Please repeat again.
In this case, I was supposed to file a rejoinder and rejoinder has been filed today. So plating, so therefore the plating part is completed, so the matter may be list for admission here.
You see, if I have understood this matter correctly,
Yes, my lord.
you are challenging the validity of posting officers at the rank of director to another department. Correct?
Yes, yes.
What is your locus standi? Who are you? Dacha Bangang, who are you?
My lord, I am town planner officer who is
You're town plan officer. How you are aggrieved by directors moving here and there?
because this is a we are challenging the bifurcation of the department from the urban local bodies
Okay.
from town planning, which was under the town
You have
planning.
any plan to stand in next elections?
My
Either
lord,
in parliament or to in the legislative assembly? Make a policy decision maker. No, this person, I'm not talking about you, Mr. Nibo. We want you here. I'm asking for this Dacha Bagan. Why does not he leave the job and stand in elections? He'll make the policy for the state. Who is going there? Who is coming here?
my lord, his contention, my petition's condition is that he is eligible.
You see, we'll tell you. This is something as an employer we always do. We have an employee, let us say that my secretary is there. He's in what post we don't know. For example, I do not know. We know, but I do not know. In what is the substantive post he is holding. But I find him effective, and therefore I say that, well, look after this job. He may be in the post of XYZ. But ask him to carry out a post. It may be an officiating post in a higher rank, or it may be a post in a lower rank. And I find him very effective. Therefore, I ask him to do that work. Can somebody come and challenge it that as an employee, you can't do that? Let us say somebody is process server in the court of CJM. Now he's very effective in office management. And the Chief Judicial Magistrate of the district judge says, please come and work in the office as a peon. It is lower in his rank, but is very effective in office management. He is brought in. Can somebody come and question that he is drawing salary of a higher post? What happens to the officiating promotions given to by the government any day? What happens to the policy where the government seeks recommendation for appointment in deputation? So we disturb the entire fabric of service culture in the entire country with my orders. We dismiss your petition on that ground alone. You don't have a right to say.
My lord, they have, the petitioner has a certain other ground also. As firstly, my lord, this instant writ petition is challenged.
You see, is it your case that somebody else has bypassed you and become a director? Any person who you consider to be a junior has become a director?
My lord, this is 2-3 point has been challenged. Basically, the bifurcation is challenged because the town planning director of town planning was holding also the authority and power and authority of urban local bodies by virtue of gazette notification dated 8.
What would you call a chief minister who is holding, say, let us say a chief minister of a state X who is holding 10 departments, 10 portfolios? What do you call such a chief minister?
My lord,
Then you will come up and say that when the minister can hold, one chief minister can hold the post of chief minister as well as 10 department. Please, consolidate all the departments. There will be one secretary for 10 departments. There will be not less than 100 and 200 posts which will, for which the government will not have to pay anything. They will retrench people.
my lord, I'd like to pray that matter may be here, fixed for admission hearing in short
No, we
date.
have full time. I have an experience of sitting in court till 10:30. Sorry, 8:30 in the night. I can continue.
In short date, my lord,
No, we are continuing. These petitions can't be tolerated.
no, because in that matter, some is others, my lord, let us go through it tomorrow.
No, you see, this can't be adjourned for even one moment.
Because it's
Why?
almost 5 days where.
My lord,
My lord, the matter may be fixed tomorrow.
otherwise, my lord, this petitioner absolutely does not have any locus. My lord, in his own department also, he is not even the deputy director. He's not even eligible, is in the feeder cadre of the director. So the
In English, there is a word.
Yeah.
In English, there is a word. I had never understood its meaning, but there is a word, busybody.
Pardon.
I don't understand the meaning, but there is a word.
My lord, this matter may be listed tomorrow.
And you know,
Yes.
the good part of it. the good part of it, that once in my family also, they all understood that I am a busybody. Therefore, I am permitted to take decision on international affairs. Yesterday, we had the news of attempt made on a former prime president. Those issues I am permitted to discuss and deliberate. But what happens at home, I am not permitted to discuss. There we have a home minister who takes a complete decision. She doesn't ask me. So, Mr. Nivo,
So, in this regard,
You
matter may be
ask.
fixed tomorrow.
no. If there is any submission, you can say it
Otherwise,
now,
it's getting-
because there's nothing. Why
It's
we
about to
should-
be 5 PM. That is why, and tomorrow, after the matter may be decided as Lordship deem fit. If the petition has no merits, then no, because then
No,
the
sir,
holding,
you read
holding
your
of
first,
the,
no, Mr. Ivo, you read your first prayer and then tell us, do we have that power? Read your first prayer. I don't have to say that petition is maintainable or not. You read your first prayer.
prayer.
Prayer in the writ petition. First prayer, read the first prayer and then tell us, does the High Court has that power?
To establish present new another department of local bodies under proper policy and guidelines of government for Uttar Pradesh.
Yes,
This is past prayer.
yes. Now, do we have that power? Does a High Court have a power to direct this, to give a direction to the state to open a new department and then frame a policy, frame a guideline? Do we have that power? To that beautiful house. That's why we're asking where is. We respect you for your legal knowledge, and therefore we are asking you, can we pass an order to the department, to the government to create a department, to frame a policy? A very recent judgment of the three-judge bench of Supreme Court. To stay the posting, second prayer is to stay the posting and function of directors of the new
And
of the
another department of urban
of
local
such urban
bodies.
body till proper policy.
Guidelines are being made by the government
Can we do it?
by fulfilling all the necessary criteria and formalities.
No, correct. Can we do it? Because I would be too happy. All my secretaries are transferred from Guwahati to principal seat to Guwahati. They're having so much of trouble. They still all transfer.
If the system is not done as per the guidelines, the honorable court may
understand.
interfere.
No, I understand. But all policies are defective. You see, which department does not have a litigation in this court? Think of one department.
Yes, that is.
Even Department of Mental Health has cases in this court. So what do? We stop all transfers. There's a lot of litigation, a lot of heartburn, no appointment. If I can do for this department, why can't I do for the entire state? No transfer, unless there's a foolproof policy of transfer. And there's an author called Robert Bloch, B-L-O-C-H. You read his book, Law of, what is this called? Law of, oh, how could I forget that book?
The matter may be refixed tomorrow again. so that it may be disposed of altogether. It is in fact long pending case also.
Oh, yes. I'm sorry that I forgot this book. It is called Murphy's Laws.
My lord,
Murphy's
Murphy's
Laws.
Murphy's laws. Yes.
Sorry, I'm sorry we dismissed this petition.
My lord, tomorrow, my lord.
No, not tomorrow. Good things must be done now.
My lord, because before going to be dismissed, before getting dismissed, I need some time to argue to satisfy myself, justify myself, because I have made this petition.
No, I'm writing
Though
my
I'm not
order.
petitioner,
I'll-
I'm on behalf
I'll-
of petitioner.
I'll write in my order that you have vehemently argued.
No, my lord, there's many other things like gazetted notification.
You see,
Dated
you
18
have-
June
you-
2010.
you-
That has been
there's a video clip going on of the very eminent senior counsels arguing in Supreme Court of India.
Yes, my lord.
You've seen that. It says that what do we mean when we say that with all respect to the judge? That means that you have not understood anything. Correct. So we'll record that. You have said with all respect. You have made that argument, but these repressions can't be tolerated. No. Heard. Mr. M. Debo, the counsel for the petitioner, also heard. Mr.
T. Omo.
T.
Omo. OMO.
O.M.
O.
Omo, Leonard.
Respondent number 4.
Leonard. Counsel for respondent number 4. And Ms. P. Pangul and the government advocate appearing for the respondent numbers 1, 2, 4, and 5. So there is no representation from respondent number 6. Next para. By filing this repetition under Article 226 of the Constitution of India, comma, the petitioner who is presently holding the post of town planner in
Town Planning Department.
Town Planning Department from a government of Arunachal Pradesh has prayed for the following reliefs, page 24-25. Next para. Notice in this writ petition was issued by order dated 15/12/2022. However, none of the respondents have filed. Is there any affidavit in opposition? No,
Affidavit in opposition has been filed.
has been filed.
Affidavit and petition filed by respondent number 4, 2,
Okay.
and 5.
Respondent numbers, the affidavit in opposition will be filed by respondent numbers 2.
By the all necessary respondents.
And 5. 2. 4. 2 and 4.
Well, 2 also has been filed.
2 and 4.
2, 5, and 4 has filed.
No, only 2 and 4. Respondent number 2 and 4 separately. The learned counsel for the petitioner has submitted that the petitioner has challenged the legality and validity of the posting of directors in other departments of urban local bodies without proper approval, guidelines, and recruitment rules. Full stop. It is submitted that the act of posting of directors for the urban local bodies where such posts already exists is unauthorized in this regard, reference is made to one of such orders dated 9/6/2022 issued by the Chief Secretary who was proposed to be posted to Secretary, Skill Development and Entrepreneurship, Sri Remo Kamki, REMO KAMKI, IAS, was presently posted as Secretary Cultural Affairs and State Lotteries, is proposed to be transferred as Secretary Science and Technology and State Lotteries Similarly, for other officers are transferred from one post to the other. Full stop. In connection with the power of the authorities to make transfer, comma, the petitioner has projected that he has filed an RTI application seeking details and copies of the government notification or policy on creation of separate and independent department, public directorate of urban local bodies, comma, copy of post creation orders by the government of Arunachal Pradesh, comma, copy of recruitment rules for appointment to the post of director of urban local bodies, comma, procedures, rules, orders, policy, acts and regulations involved to review the decision of the state cabinet and for being furnished with a copy of legislation, comma, acts, comma, rules, comma, order, comma, policy, under which decision by the cabinet can be reviewed by the chief minister. Full stop. On non-receipt of such information, comma, the present writ petition has been filed. Next paragraph. We have heard the submissions made by the learned counsel for the petitioner. Next paragraph. The court is of the considered opinion that the nature of prayer made in the writ petition, comma, as extracted hereinbefore, comma, or relate to the policy decision of a state, and it is a trite law that in matters relating to policy decision of the state, comma, constitutional courts should be very slow to interfere. Next paragraph. To issue a direction to the state respondents to establish new department and to frame up policy and guidelines is a purely legislative function which cannot be usurped by this court. Full stop. The prayer to stay the posting and functions of the director is nothing but preposterous. Full stop. The court would have no power to pass a sweeping order to stay all the transfers, which is always held in judicial pronouncements to be prerogative of the state. Full stop. The third prayer to allow to retain all the power and functions of urban local bodies to the present director appears to be a motivated prayer. In the interest of the person who is presently occupying the post of director of town planning. Full stop. In this regard, the court is of the unhesitant view that the petitioner is nobody And a petitioner in holding the post of town planner is nobody to ask the government to allow all power and functions of urban local bodies to be held by the present director. Full stop. In the event, next para, in the event the petitioner does not want such powers to be divested to others, comma, he is a person in the free country and he is free to live independently and not as a government servant. Full stop. This is merely a passing remark and not a neither an opinion nor a direction to the nor a direction nor an advice to the petitioner. Full stop. However, as he has entered service, comma, it is the duty of the petitioner to know the rules, regulations under which he is guided to perform his duty. Full stop. Next para. Therefore, comma, having held that the petitioner has no locus standi to make prayer in the nature of prayer number 3, comma, the court is compelled to hold that the petitioner has filed his writ petition with an ulterior motive, and as we have held that the prayer number 1 and 2 are policy decision of the state, comma, the court is inclined to dismiss this writ petition. Full stop. Next para. However, comma, on the earnest prayer made by the learned counsel for the petitioner, comma, we refrain from imposing exemplary cost on the petitioner.
My lord, impose cost.
I have refrained. You want to impose cost to be imposed?
No, my lord.
Okay. I have refrained. I told you I will write in your favor.
Okay, obliged, my lord. Obliged.
This is something we have written in your favor.
Most obliged.
Yes. I may not pass orders because tomorrow it not be possible. Because we've already it's 5:15. This you can accommodate next Monday if you want.
I was getting from outstation.
Oh. But tomorrow we can't accommodate.
Day after tomorrow.
Day after? Okay.
Yeah.
The item?
Well, item number 24, I will be allowed to take dusty service upon private
No,
response.
we can't pass orders because they'll be in difficult position. My stenos can't they take the dictation for all the orders. In item number
Item
25 and 26. The learned counsel, the positive time matter cannot be taken up today. Most of the learned counsel submits that he is an outstation counsel and prays that the matter be listed on Kalkale. Day after tomorrow, huh? After tomorrow. So prayer is allowed. List on so and so. The list is already out. I know.